Now, whether you have received now. So these 32, 33, 34, 35, these are all connected. So what is your submission? No, no, no. Yes, Mr. Counsel, what is your submission? Adjourn for the day. It may be adjourned because we have not received the case diary. And all are on interim or what? Interim is there. You are appearing for 32. You are for 33. 34, Mr. Paramanik, 34 and 35. Yes, Mr. Potago, 34 and 35, whether they are also in interim? All right. Thirty-two, 35. CD not updated case diary not received. Issue reminder. Further, also considering the submission made by learned for the petitioners. Matter is adjourned. And let the matter be listed accordingly. Yes, Potago, it has to come from which district? 18th. We are listing all the matters on 18th of June. Your interim will be continued till next day. Okay, interim court. 12. But have you informed the other side? And guest counsel? D. Borman has already informed the other side. Achha. City not received. You are Mr. Mr. A. Thakuria appearing on behalf of Mr. D. Borman for the response number 2. And it is submitted that with the consent of with the submitted and with the consent of the other side, he prayed for an adjournment stating that respondent needs some more time to file their written objection. In the meantime, Mr. Botakur, at the same time, Mr. Botakur, the learned additional PP also submitted that CD is also not received. Issue reminder for CD. List the matter accordingly, yes. 22nd of November, enabling the respondent side to file the written. We are here, we need the case diary. That is, the matter is still under investigation. In that case, whether any stay is operating? No. No stay. No, he is for the respondent. Okay, okay, 22.5. Oh, sorry, 22.6. Yes. Hmm. You want to withdraw the same? Hard Mr. A. Datta, the learned counsel for the petition, submitted the with as by instructions of the petitioner. He wants to withdraw the same. Considering the submission made by Mr. Datta, the prayer is allowed. Matter is accordingly disposed of and withdrawn. Personal request. Part heart was as yes, Mr. Counsel, whether it is part heart matter. No, you're saying that it is a part heart. Delivery of order today. Sorry, before Justice Muzumdar. Sorry, 27, 28. Otherwise, what had happened yesterday, we received VC request, both for 27 and 28, because the council is from Arunachal, Mr. R. Sonar. So he made a VC request, we allowed. We didn't know at that time that it was, pardon? Supposed to management. I, there was the delivery order. We don't find any delivery of order, dear. From where you are saying delivery of order? Now what to do? There is no, this, it's not part heard. There is no order for delivery of order, not fixed for delivery of order, not even a part heard. No sound need to VC request was there. Now you're going to pray for adjournment if it already been argued by Mr. Sonar before Justice Mozumdar, then it's okay. I won't, we were not, we don't have anything to say. But I don't know where from you're saying that it is for delivery of order. In 27 and 28 also, he was in petitioner in person. He also made a VC request in both the matters. কি করবে? 28 is matter is also connected matter. Okay, then let Mr. Sonar be appear or the yes, yes. 21. You are on interim. Sit in proceed issuement. Yes, Botako. 16th. 1/6. Interim be continued till next date. 23. Oh, in that case, I don't know. In for protection for up till appearance to, we need this test scan copy. Otherwise, we are extending your 15 days. That will do. Yes, CS number. Mr. Arpura 15 days extended. So we are extending your interim up to 15 days so that you can appear with a regular bill application. Your will name will be 13. Injury report was called for, na? Page number? He surrendered. Hard Mr. M. Hawkilane, counsel for hard Mr. P. Bot, Hawkilane, the Disney people, it's an application restrictions is submitted by Mr. Botwood that the case ought to have been listed in the hearing column. So inadvertently it has been listed in the motion. However, the CD and the injury report which was called for is not received from the I. Next part, Mr. Hawk, the learned counsel for the petitioner, submitted in the that there was a dispute and quarrel between husband and wife, wherein the wife of the present petitioner sustained injury as per allegation. However, as per his instruction, she has already been released, and there was a simple dispute arose between them on the day of incident. There is none to look after the two minor children of the petitioner, and that upon the accused petitioner himself surrendered before the learned trial court below. And since 20/04/2026, he is in custody. Thus, the IAG got sufficient opportunity to interrogate him, keeping him in custody, and hence further custodial interrogation may not be necessary for the interest of the investigation. Next part. Mr. Portable submitted in this regard that from the FI itself, it is seen that she was injured with a sharp object, and at the at the time of lodging of the FI, she was under treatment. So, considering the nature of the offense, he insisted to call for the case diary and the injury. Next para, hearing the submission made by and considering and without going detail into the other merit of the case, only considering the length of detention undergone by the accused petition. This court is of opinion that further custodial detention may not be necessary for the interest of the investigation. Accordingly, I find it case. This case is of Sipajar, that is Dorong, CGM Dorong, to the satisfaction of CGM Dorong. Okay, granted. It will be, I'll go up before CGM first. अजीब अच्छा वो दी मेथड कितने डिलीवरी
My pleasure, Lordship.
Yes.
Lordship, the 103 is there, Lordship, and CD may be called for, Lordship, in this case. But as on today, Lordship, at 41 days in custody, Lordship, apparently, as per the instruction, Lordship, and the murder is committed by other person, Lordship, but subsequently they are projected in this case. So, well, CD may be called for and for that possible. And 41, 8th of June, Lordship, can it be? On 10th of June.
Let's see the
Lordship.
Okay.
Along with PM report, Lordship.
Yes, along with.
Published, Lordship. Published.
Yes.
Miller, a regular bail application, my lord. Miller, FIR is in page 16. What happened, my lord? I'm carpenter.
Hmm?
I'm carpenter and working with the informant, my lord. After I opened my own shop, and therefore some enmity is growing. My lord, previously I got interim bail from this honorable court. Thereafter, my lord, interim bail was rejected by this court also.
That was my AB, my lord. AB earlier rejected. And thereafter, the present petitioner was arrested on 1/4/26, my lord. And page 33 is the, my lord, your lordship, make page 33, paragraph 9, your lordship, make up your, the statement of your lordship.
And my lord, today is
Paragraph 30, 30,
Yes, ma'am.
33.
Page 33, your lordship, serial number 9, paragraph, my lord.
Right.
Fourth paragraph, serial number 9. The statement of the witnesses also reveals
Hmm.
that the accused Nitul Rajbamsi is the petitioner, my lord, went to Ma Furniture Shop at about 10:11 p.m. and Nitul Rajbamsi abused the owner and other carpenters present in the furniture shop. The statement of the lady so and so revealed that at about this sort of set fire, and she also saw a white man. The case diary also revealed. Earlier also, in the CD, there are materials against the accused.
today I was behind the bar 52 days. And my lord, the rejection order, my lord, was session court, page, my lord, kindly see page 33, para 9.
Yes, he just. Para 9, he just read para 9.
Page 53. For death, my lord, only, my lord, reject my bail. So, since the matter is, my lord, 20, August 25, my lord, investigation may completed. Whether further custodial detention
It
is
is a 90 days
necessary.
offense.
Yes, today is 51 days, my lord.
Not today is 51, it is a 90 days offense.
Yes, 90 days. 90 days. Well, any short date may be fixed, my lord. I can produce on next week also. I can produce the CD on 28 or 29.
We are not listing next week.
Then on 2nd of
First of
3rd June.
CDB court for first of.
Blameless.
Before
Please, Your Lordship. Lordship, this is 482 of VNSS. Lordship, the FIR is at stage 11.
Mm. So what is your case?
So Lordship, here my case is that this FIR states that one Asif Ali have asked for the money. But me, the present petitioner, is a political leader, and Asif Ali is working under me. So the vehicle which was used is mine, petitioners.
Asif Ali
So-
and he only recognized one person very well among
Asif Ali.
three individuals.
Yes.
One is
So
Asif
this
Ali.
person, my petitioner is nowhere related, Lordship. And moreover, the ingredients of this section, theft and robbery, does not come. Attract.
You are the owner.
Yes, I am owner of the vehicle only. And moreover, I am a political leader.
At least the city may be called allegations are
That's
stated,
it.
only he identified, recognized only one person, Asif Ali, but they along
And
with Asif Ali,
later on-
all other three individuals, other individuals also there. Maybe he is one of the individual. So city.
Later on, we came to know that Asif Ali has been arrested also.
Because Asif Ali was recognized by the identified by the
And Asif Ali only has to get money from that complainant, Lordship, not me.
But allegation is that they afterwards they dropped me out of the vehicle and went to the SP. Four-wheeler taken me and forcefully took away rupees so and so from me. So getting some.
But the sections are not
Was there
attracted
any
for the
media
petitioner,
why
Lordship.
why the person will pick up randomly from a
Yes. City will reveal Melot. Otherwise, prima facie there Melot. These sections are maybe some dispute between them. Maybe there. Those are.
It's not serious, no severe case, Lordship.
But at this stage,
Only the vehicle was mine. We were together.
only his vehicle was the if vehicle is the he is the vehicle owner. Technically, he was and he may also be present in that vehicle at the time of committing the offense.
so in that case what you want?
Lordship.
I mean what Mr. Botakur is submitting that you are the owner of the vehicle
Lordship.
and the victim could only identify one Asif. That apart he could not identify the others.
Because the party does not have anything to deal with us, Lordship.
Huh?
The party, the complainant has something related to with Asif Ali only, not with us. Not
No,
with
he
the
could
petitioner.
identify Asif only,
Yes,
but
Lordship.
rest he could not identify.
Yes,
Yes.
That is the case.
Lordship.
So we don't know your petitioner may be there. Though he undoubtedly he a registered owner of your vehicle, but his presence, how can you deny his presence? Merely because he is the registered owner of the vehicle, you cannot say that he was not there. Is there anything? Is police is searching for you? No.
No, no.
Police
This
is
is searching, Lordship.
Let them appear otherwise.
At this stage, interim protection may be granted, Lordship.
You are not answering the question. And then how you are
No.
heard MSSC America also deputation also had this report. Still an additional PPA being the opposite response. This is an application. It is submitted by MS Ahmad that the present accused petitioner is innocent. He is no way connected in the however, it is a fact that he is a registered owner of the vehicle which could be identified by the victim. That apart, he is no way related in the case. However, he is ready and willing to extend his cooperation in further investigation of this case if he is granted with some information. Next one, Mr. Alberto, he ran it additional BP, raise objection, and submitted that the victim could identify only one person out of three persons, and at present it cannot be said that the petitioner was not present at the time of incident. Accordingly, he insisted to call for the case trial. Next one, considering the submission made by land counsel. And this court is obtained, and that one opportunity may be given to the present petitioner to appear before the IO and to extend his cooperation with your interim protection. Okay, you'll be under interim protection till receipt of the case time. Appear before the IO, there will some conditions, abide by all the conditions.
That's
On 17th of
70,
17th.
17th.
yes, that's it.
My resolution. My lord, this is PRS bill application and FIR is lodged by my wife, my lord, against me. And basically, allegation is there. I have Salman's second marriage with her by suppressing earlier marriage, first marriage. And another allegation is there, my lord, forcibly abortion and torture and not giving maintenance. These are the basic allegations in this FIR, my lord. Kindly see the page 9 is the FIR. May I read, my lord? Yeah, this FIR is para-wise. I would like to read out the para number 1, my lord. The accused Abdul Kader, aged about 38 years, son of Hus Mahmud, resident of village Bortola, police station Kajolgaon, Chirang, district, married on 5th June 24. In the year of 2024, today is 26 May, almost 2 years, my lord. After continuing her conjugal life, almost 2 years, she came to know about my earlier marriage. This is not believable, my lord. Now, kindly see, my lord, para 3, my lord. At the time of marriage registration, as per Muslim marriage rules, we agreed upon then mohor, rupees 5 lakhs. The accused give me old ornaments worth only 21,000. However, the falsely wrote in my marriage register document 125,000. My lord, this is the main problem actually, my lord. Rupees 5 lakh was del mohor. Now, my lord, she was demanding on that point. I will come later on, my lord. Before that, my lord, kindly see para 4. Since the day of marriage, accused has failed to provide me the daily necessities or essential items, he has subject me to mental and physical torture. Most seriously, the accused forcibly aborted my 2 pregnancies. First 1.5 month and second 4 months. Aborted forcibly on 5th June, 5th February 26. After the last abortion, the accused completely stopped providing any maintenance and resuming torture. These are the allegations, my lord. Actually, this is not believable. After continuing conjugal life 2 years, she came to know earlier marriage about. And I have admitted, this is my second marriage, my lord. Now, my lord, kindly call for the CD, and in the meantime, I may be protected, my lord, because purely matrimonial dispute here, my lord. And she, but in this case also, she claiming about maintenance, etc. These things, my lord. Kindly call for CD and some protection with it.
Well, first of all, prima facie initial deception is there. He conciliates earlier marriage. Thereafter, my lord, continuously, my lord, she, my lord, the accused person tortured her, my lord. Since the day of marriage, the accused has failed to provide, my lord, so all these regarding all these mental and physical torture. And paragraph 5, my lord, specifically dates mentioned, my lord. When 2 times, my lord, he was, my lord, 4 months ago on 5th of February 26, and one in, my lord, the 2 specific date, my lord, specifically, she has also enclosed, my lord, medical document regarding that. So prima facie, it seems that
And
torture is there, my lord, mental and physical, and my lord, initially, my lord, he concealed her earlier marriage, and thereafter continuously harassed the present petitioner, present informant regarding that aspect of material. Prima facie, it seems.
Basically, main problem is here actually, rupees 5 lakh Delmo. And she, as per our information, she, her also second marriage, this marriage. As per our information, my lord.
Now he admitted his second marriage, but before marrying her, my lord, he concealed everything, man. So initial deception is, my lord, there, my lord. And thereafter, my lord, on prima, there are two specific dates, my lord.
And my case,
She was forcefully, my lord, forced to abort, my lord. And regarding those specific dates also mentioned.
but my case, I have mentioned here, I have concealed nothing.
Final fishing, my lord, there is material in the FIR.
I have concealed nothing. She knowingly, after knowing about my first marriage, she solemnized marriage with me. This is my case, my lord. And she already continued her conjugal, 2 years conjugal life. And then he lost this complaint.
Mr. A.K. has regarding consultation. So, Mr. He bought 40 land in additional PPM in status. Application section so and so. It is submitted by Mr. The that they with false inform some form of application taken against him. However, he admits that this he was earlier he married the no, no, the informant is his second wife and then there was some dispute with regards to Mohar, which was stated to be 5 lakhs as per her. That apart, there was no such incident took place in the between them. And after 2 years of their marriage, she lost the FIR. Though it was well within her knowledge that he earlier got married with another lady. He earlier married with her. However, Krishna is willing to extend his cooperation in the further investigation of this case if he is granted with some interrogation. Mr. Bordoputilan recently submitted that from the plain reading of the FI itself, it is seen that there was a deception at the beginning of their marriage, and he never disclosed his earlier marriage. That apart, there is clear allegation of torture and abortion of her abortion, 2 times abortion of her pregnancy. She also annexed some medical documents along with the FIR as it reveals from here. Mr. Board accordingly submitted that CDB reviewed the actual facts and insisted for proceeding. Also, during this submission, the council both sides within the case record. This court is confident that one opportunity may be given to the present petitioner to appear before the IO and to cooperate in the investigation process. In view of this, provide available. Okay, will be under interim protection.
Right.
On 15,
15-6.
18.
86.
I'm obliged.
May I please, Lordship? So this is clear is well application, Lordship. Lordship,
Yes, registered no. FIR not yet registered.
Not yet.
yes, Lordship. But on 2/5/25, 26, Lordship, Lordship, police visited the house of the petitioner and also visited the business place of the petitioner, Lordship.
Huh? Also,
Lordship, on 2/5/26, Lordship,
Huh.
police of Barbata Road Police Station, Lordship, visited the house of the petitioner, Lordship, to arrest him. So
why?
report
Is there any case?
no, Lordship, no information has been given to the petitioner, Lordship.
No.
Wait,
Case is not yet registered. And
Lordship.
why there is an apprehension or why police is searching for you as per
Lordship.
you?
Lordship, kindly see para 3, Lordship. I have
Hmm.
clearly mentioned in para 3, Lordship. This is
Plastic carry bags.
this purely civil in nature matter, Lordship. One Manoj Goyal, Lordship, threatened the petitioner to that he has lost an FIR before Barbata Road Police Station, Lordship. So report to be called for whether any FIR is registered or not.
You are Mr.
Yes, Islam Lordship.
S. Islam. Now to 90 heard Mr. S. Islam, then constituted petition, also heard Mr. P. Ward. They learn additional PP appearing on behalf of state responsibility. This is an application, section 482 PLSS, being for PLS to bail. With an apprehension of arrest in connection with any case to be registered under Prohibitions. Next part is submitted by Mr. Islam that there was a business dealing with the petitioner and with one Manoj Goel from Delhi, and there was they dealt with business of plastic bags. But subsequently, there was some dispute between them, and said Manoj Goel had threatened to lodge an FIR against him. On 2/5/2025, and some subsequent days, the police also visited to the house of the petitioner, and hence he has the apprehension of arrest, and accordingly prayed that some interim protection may be provided. Next program, Mr. Water put his objection and submitted a report may be called for from the concerned police station, but at this stage there may not be any interim protection. May not be any interim protection to the petition. Next paragraph, considering the submission made in Google sense and the nature of offense as stated in the file. Let the report be called for from Kolkata Police Station as to whether any case has been registered against the present petitioner. Until receipt of the case diary, it is directed to the police from Kolkata PS not to take any coercive action till receipt of the matter accordingly when it can be
On my lord, 3rd of June.
released on track. Okay, there will be some interim protection.
Lordship. I'm deeply obliged, Lordship.
May I please the Lord?
Yes.
So not pre-arrest bail application, my lord. Yeah, for my lord, phase 12, my lord. Yeah, my lord, the petitioner number 3, my lord. And informant's father, their brother and sister. And informant's father, my lord, he allowed us to stay in their land about 30 years back. We are staying there. And thereafter, my lord, sale agreement was made. They wanted to sell to us and we paid the money, but sale deed was not executed. Now they are not executing the sale deed and they tried to evict us from the land. We have cut some trees, my lord, then this cause of action arose, my lord. Page 12, my lord.
Anyway, this may be a civil dispute is maybe
No, no.
there, but allegation of
They have, my lord, made some allegation, my lord,
118 is also there.
lordship.
1182 is also
Lordship,
there.
that was, section has been added, my lord, there, my lord.
And my lord,
But no such incident took place, just couple took place, my lord. In this regard, my lord, we have also filed FIR on the same day. Page 27, my lord.
finding sufficient materials for a trial court rejected, my lord.
Then-
Rejection order is at 39.
The petition number, my lord, 2, 3, and 4, my lord. 3, 4, and 5, my lord. They are all women, my lord, and petition number 5, my lord, she is pregnant. We have annexed the medical document also, my lord. Admittedly, family dispute, my lord. We will cooperate with the investigation. Medical report may be called for, my.
Regarding lady, do you want to some?
So yes, finding sufficient materials for a trial court rejection order is at page 39.
Yes, that I have
Yes,
known
and
regarding
regarding
three,
other
four, and
materials, your lordship, there are
Regarding-
specific materials against the accused person, your lordship. Vernacular at my lord, page 3, here petitioner accused
But-
number 1 is the Jawahir Ali, my lord.
Ah.
Against Jawahir Ali also, my lord, that আসামীজনে পৰিকল্পিতভাৱে ঘৰৰ ভিতৰত পৰা কাঠৰ বাটাম, লাঠি আদি লৈ দাদা জহিৰুল হকক গুৰুতৰভাৱে শৰীৰত আঘাত কৰে। জৱাহিৰ আলী is the accused number 1, হয়। কাঠৰ বাটাম দি জহিৰুল হকৰ কান্ধত জোৰকৈ কোব মাৰে। লগতে জহিৰুল হকক আসামী ক্ৰমে 1, 2, 3 মাটিত পেলাই লাঠি খুচি বাটামৰ কোব দি বাটামৰ কোৰ ইত্যাদি দি অজ্ঞান কৰি পেলাই থৈ যায়। And regarding other accused also, my lord, 3 নং আসামী কাছেম আলীয়ে আফজল হকক দাৰে মূৰত কোব দিয়ে। And against my lord, all these accused persons, my lord, at that point of time, along with them, those weapons by using those weapons, my lord, assaulted them.
এক, দুই,
Against
Qasim Ali is in custody, man.
against accused number 1, 2. Here petitioner is accused number 1, 2, 4, 5, and 6. And against 4, 5, and all of them, my lord, there are specific allegations.
4, 5, and 6 are also there.
Yes.
Allegation against 4, 5, 6.
Yes,
There is a direct allegation is not there regarding assault, my lord. They are all family members. They attack our house, my lord. So we are in the place of occurrence, my lord.
all accused were.
And in the rejection
the
order-
house of the accused, Udal, Bah, Kathor, Batam, ityadi, all these accused persons, my lord.
In the rejection order, my lord, medical report was not discussed, my lord. Nothing, my lord. Just, my lord, implementing materials.
Considering at this stage, my lord, CD may be called
So-
for, because there are specific materials against all these accused persons. And my lord, at present, regarding the injury report,
Who is pregnant?
5, my lord. Alia Khat. 3, 4, 5, they are women, my lord. 3 is their wife of petition number 1. 2 is 4 is, my lord, 4th husband arrested, my lord.
Heard Mr. R. Ali Dilane, counsel for the petition, and also heard Mr. P. Watford Dilane, additional PV, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Ali that the present accused petitioners are innocent and they have not committed any such offense as alleged in the. However, it is a fact that there was a land dispute between the two groups and the altercation and scuffle took place, wherein both the sides sustained some minor injuries. For the alleged incident, they have also instituted lodged an FIR, which has also been registered against the informants. He further submitted that the accused petitioner number 3, 4, and 5 are the women, and the petitioner number 5 is a pregnant lady who is pregnant lady. So considering all these aspects of the case, some interim protection may be provided to all the petitioners so that they can appear and cooperate in the investigation process. The next one, Mr. Bott, additional PD, raised objection and submitted that from the FIR, also it is seen that all the accused petitioners are involved in the alleged offense, and the bail petition of the petitioners were also earlier rejected by the learned trial court below. Considering the materials in the case diary and the nature of it. He accordingly submitted that the city may be called for know the action. Next one, hearing this submission made by learning counsel for both sides. And this court is of opinion that the interim prayer for accused petitioner number 2 and 5, 3 and 5 is hereby considered. And the prayer in interim protection for petitioner number 1, 2, and 4 is hereby rejected. He is not considered at this stage. 3 out of 5 of people. Your
Okay.
3 and 5 will be under interim protection.
3, 4, and 5.
No, only 3 and 5. 4 is pura she is so ekdam with cut her bottom. She is
Yes.
engaged herself in beating and only 3 and 5. Yes, what when it's
I don't know, 15th of June.
medical report along with
Obligation.
May I please, your lordship?
yes.
For 82 application, lordship, FIR is page 9, lordship. 11 page, lordship would find, lordship, page 10.
Yes.
Page 10, lordship. Lordship, may I read, lordship?
Yes.
With due respect, I would like to state that my sister, Arpana Pandit, since disease has been serving as Birangana under Assam Commando Battalion and was stationed at Mandakata camp. As informed by concerned department last night, she was discovered to be dead in her room at her camp, and a note was found alongside her, which upon perusal clearly reflect that she had committed suicide on being driven by extreme undue mental pressure exerted upon her by senior colleague from Kumari Khatura, the writer of the camp. Further, we would like to inform you that my deceased sister was harboring a cordial relation with one Lakhinder Singh, a CRPF personnel, probably posted near Rani, Gauhati. And as a matter of fact, and to our knowledge, my sister had a regular telephonic conversation with Lakhinder Singh. So we apprehended he might be able to share some valuable information as regard the mental condition and eventuality leading to my sister to take such ultimate step. I request you to kindly. So after receiving that, lordship, Bahata Sahili PS case under section 108 BNS was registered, lordship. Lordship, what happened, lordship, in this case? I am a lordship Lance Nayak and writer of that Mandakata. My duty is to, lordship, allot duty as per the direction of my superior officer, Subedar Major, and the commandant, lordship. That the petition victim himself, herself, lordship would find page 14, 14. Has applied for earned leave, lordship, of 30 days prior to that, lordship. Lordship, in bottom part, lordship, it was authorized by commandant of the 1st Commando Battalion on being forwarded by Subedar Major. Lordship, I have no role in granting, allotting, or detailing her duty, lordship. She, lordship, want to have a outstation visit with that Lakhinder Singh, which I cannot allow her because I have no authority. And out of what happened, lordship, he committed suicide. Merely mentioning my name in the suicide note, lordship, I am apprehending arrest, lordship. And regarding law, lordship is aware, lordship, there is no any direct inducement or instigation from my part. So at this stage, lordship, CD may be called for, and I may be protected, lordship. I am also service holder, lordship, in the same thing.
Well, suicide note specifically implicated
Yes.
the present petitioner. So suicide note is necessary, man. Only after perusal of the suicide note and
Let the short date it is
yes.
first or second of the by report.
Yes.
First, we are listing
Yes.
short date 1st of June.
Lordship. In the
No
meantime,
interim
lordship,
protection, yes. No interim protection is provided. 1st of June, we are calling for the case day along with the that suicide.
Hmm?
1st of June.
lordship. First of June.
May I please your option, my lord, pre-arrest bail application. There is a specific allegation against me that, my lord, I have assaulted the victim, my lord. So I pray lordship will call for the case there in this case.
You are for the other side.
For the informant, your lordship,
Inform.
other side.
Mr. BM. For the
Interim disseminate.
So the petition and also heard. Mr. P. Bottakuru, Delaney Litigation, PP, appearing on status. And Mr.
A
Iqbal.
and Iqbal. A and Iqbal.
A and Iqbal, Delaney Council, appearing. Let the CDP call for, yes, Bottakuru.
Second of the
Second is, many matters have been fixed, I think, second, third of June, at least.
Your Lordship, shall I get an opportunity to file an objection, Your Lordship?
You want to file? Considering further, third of June, further considering the submission made by the learned counsel for the informant, Mr. Iqbal. He may file his written objection on or before next.
Objection.
No, no. Okay, 30 yes,
May please, Your Honor.
Yes.
A report was called for from the Golakan speech.
report was called.
So regarding service of scan copy of PCR also not received. The certificate case earlier PCR was called to me.
What kind of report this is?
Report only service. of
Whether
notice-
case has been?
Yes, POSCO is there, service of notice to the respondent.
Oh, service of. No, whether case has been registered initially, we are want to see. I don't know, what is this case?
Fish
It's
number.
a POCSO case.
Fish number. Jegon mes na jan.
POCSO?
No, report.
Registered.
Supply 32 14 data. কিমান আছে আৰু? এইটো নহয়। No, I have a ভুল কৰিছে. My lord, wrong file has been provided to us.
It's only report was called from the concerned police station, that is officer in charge of Golokganj PA,
Golakan.
Yes, my report-
regarding registration.
Your lordship may kindly fix day after tomorrow I will get that.
Monday,
On them.
you just take it in.
I don't know, that's a ভুল file টা দিয়েছে।
Hard MSP Katunia, S Katunia, Dilane. It's the matter on Monday is Kimantari. 25/5
Yes.
for report.
এটা ক্যামেরা তুলি
Yes.
This is application under section 528 BNSS for quashing of FIR, my lord, which was lost on 5th May 2026, my lord. Before gone through the FIR, I'd like to read out the page 18 for a moment, my lord. Last page of this petition. This FIR also lost by my wife against me, my mother, my sister's husband, my lord. And after this FIR, we are amicably settled the dispute, my lord. And so this FIR shown by informant, which is my wife, and she's saying that entire incident arising out of some matrimonial
It is
dispute.
still under investigation, I think. So we call for case there.
My lord,
Still under
Section-
investigation.
all these sections are 85, which is 498A earlier.
No, we are not going to pause the matter unless and until we fail. Do you have also appeared before the IO?
Yes, informant.
The informant appeared?
Yes, informant appeared and she has submit one
Affidavit?
withheld the request letter, মানে compromise letter
Acha, before the police station.
before the
Okay,
PS also.
that will come along with
But-
our head.
I'm paying some
Right.
stay, my lord, because
No,
who's searching us?
We are not, we,
Right,
our
Mr.
neighbors
Rocky,
stay
I'm-
any inquiry, neighbors stay. Hard Mr. Ekya said, done. So hard Mr. P. Bottom. They learn it, additional PP, appearing on behalf of state respondent. This is an application. Section 528 PNSS for quashing of the FIR raised, which is registered by Tola PS case number 72 of the 2026 under section 85/1172/296 small a 3162 3242 3513 oblique 3 5 of BNS. Let the case diary be called for. Yes, Bottakuru, from Dhula, na?
From Dhula, my lord,
When it can
police searching us, sorted if possible before
No,
Short date 20.
before short date, we
On my lord, 15th of June.
It will show longer. First week of the.
First week would have 10th of
June.
might be very big.
Hello.
Yes, okay.
But in this case diary was called for. Case diary received. Lordship, in this case, Lordship, it is a case of mob lynching leading to the death of the victim, Lordship. What had happened, Lordship, the person who died, Lordship, he had an affair with a girl, Lordship, accused number 1. So he went to their village to meet that girl, accused number 1. And thereafter, this person who died, he was intercepted by the villagers and the family members of accused number 1. And he was assaulted, and thereafter his body was found near the railway line, Lordship. Now, initially some persons were apprehended. These are the persons I am on, Lordship, on behalf of 4 persons, Lordship, and these persons were arrested much later, Lordship. They were arrested on 20th of April, Lordship. Other accused persons were arrested after the incident, and as far as my accused persons are concerned, they were arrested on 19. They were produced before the court on 20th of April, Lordship. Now, my respectful submission is that apart from the merit of the case, that the grounds of arrest were not properly communicated to either the accused person in compliance of section 47 and the family members. They are vague and omnibus ground, Lordship. If Lordship may come to the ground, Lordship, the arrest memo is at page 23, and thereafter page 25 is the notice under section 47. If Lordship comes to page 25 of my petition. Very mechanically projected in the section 47 notice. If I may lead your Lordship to point number 3, detailed ground for such arrest. The statement of the earlier arrested accused person have identified him as one of the main culprits for the cruel and brutal murder of the 19-year-old so and so. And thereafter, Lordship, at serial number 7, arrest of the accused person was necessary for proper and effective investigation of the case and to apprehend and arrest the other co-accused person to whom the accused person have conspired to act such a brutal murder. Thereafter, at page 26, the accused person have done the act with common intention, which led to the death of a young 19-year-old so and so. So these are the grounds of arrest. And thereafter, if Lordship comes to the section 48 notice, which has been communicated to the family members, there also same grounds of arrest were mentioned by the investigating agency. At point number 3, page number 27, ground of arrest, serial number 3, the statement of the earlier accused person have identified them as one of the culprit for the cruel so and so. It is the same as the notice under section 47. Thereafter, point number 4, if the accused person is not arrested, there is strong possibility that they may abscond and hide himself from the locality. Vihan Kumar judgment is very clear, Lordship. The ground of arrest has to be specifically communicated to the accused person as well as the family members. In fact, it says that communicate is a strong word. It means that sufficient knowledge of the basic facts constituting the grounds should be imparted effectively and fully to the detainee in writing in a language which he understands. Then that is how in case of Pankaj Bansal, initially it was laid down in Pankaj Bansal case, and thereafter it was referred in this Vihan Kumar judgment, that is how in the case of Pankaj Bansal, this court held that the mode of conveying to the ground of arrest must necessarily be meaningful so as to serve the intended purpose. So in my respectful submission, the grounds of arrest which has been communicated is not at all meaningful to serve the intended purpose. And it is itself a violation of Article 21 and 22 of the Constitution of India. And I have annexed, in fact, all the notices of all the accused person. First is that of accused person
Sarath Hira, 25 to 28. And thereafter, page number 29, another accused person, Bukhol Das, same ground of arrest. It has to be specific. What are the account on which date FIR was lodged? What are the contents of the FIR? The FIR should contain all these materials. This, in my respectful submission, the notice which has been served upon the accused and the family members is no notice as per section 47. It does not serve the intended purpose as per Vihan Kumar judgment and the Pankaj Bansal's judgment, Your Lordship. It has not served the intended purpose. And as far as the merit of the case goes, and these persons were apprehended much later. They were not present at the place of occurrence. In fact, when the commotion took place in the village, they came to the place of occurrence after the incident. They heard about the incident from the villagers. A commotion took place within the village. When they came, Lordship, police party also came, and these police could gather their names, and thereafter they were also intercepted and arrested, Lordship. It is a case of mob violence, Lordship. Proper identification of accused was not done. No TIP was conducted. They are in custody for last 1 month, Lordship. They were arrested on 19th of April. They were produced on 20th of April.
So we have received the
They
case.
are not named accused person.
So we have received the case, Your Lordship. It is very unfortunate that a 19-year-old boy was brutally assaulted and brutally killed by these petitioners along with other several persons, Lordship. And as per the postmortem report, death was due to bilateral pneumothorax following the thoracic injuries described. All the injuries sustained were antemortem caused by blunt force impact and homicidal in nature, Lordship. In the own injury part, Lordship, several multiple injuries are there, Lordship. A stitch shoulder of length 4 centimeter with 3 stitches in situ present on the right side of forehead, 3 centimeter from midline and 2.5 centimeter above. Sprabotial ridge, a stitch shoulder of length 3 centimeter with 3 stitches. Lots of injuries are there, Lordship. These petitioners were assaulted by this with rod, lathis, etc. Lordship, along with several persons. And Lordship, regarding and witnesses concerns, they were fully implicated by the witnesses also. And they also admitted, yes, we have assaulted the disease, Lordship. And regarding the compliance of 47, 48, and 36, Lordship, it's clear enough stating that what they have did in the past, Lordship, the accused persons have done the act with common intention, which lead to death of young 19-year-old Siva Chauhan. In Assamese, they have signature date, Lordship. In অভিযুক্ত ব্যক্তিসকলে একেধৰণৰ উদ্দেশ্য কাৰ্য কৰি 19 বছৰ 19 বছৰৰ শিৱ চৌহানৰ মৃত্যুলৈ লৈ গৈছে। That is sufficient enough to what they have committed, Lordship. So regarding the 47 and 48 notices, we have fully complied with, Lordship. And my humble submission is that, Lordship, they have assaulted a person brutally and killed a 19-year-old boy. At this stage, I mean, several persons yet to be arrested. So at this stage of investigation, it is my humble submission is that it is not a big case for granting bail at this stage, because several persons will yet to be arrested again.
Heard Mr. Ganguly to learn counsel for the petition. Also heard Mr. D.P. Goswami to learn petition and an application. City receipt by Mr. It is submitted by Mr. Ganguly to the present accused petitioners and they are not at all connected with the alleged offense. They were not also named in the FIR, and subsequently, being the resident of that locality, their name may be collected and they got arrested in connection with this. We further submitted that there is no proper compliance of section 47 and 48 BNSS notice as per the guideline of honorable application in case of the He further submitted that the languages of all the notices under section 47 to the accused persons and 48 to the family members are same, and their uh, and they're not, they cannot be considered as a proper ground of arrest. A proper ground of arrest as per the judgment of the Honorable Apex Court in Bihan Kumar's case, which should be a most necessarily meaningful and so that the accused person can understand the reasons or the grounds of arrest under which he or she arrested in connection with the said case. Thus, there is total violation of Article 21 and 22 of the Constitution of India, and the on same ground only they are entitled for releasing on bail. Mr. Ganguly further submitted that the accused person heard about the incident and they came later on to the place of incident, and considering their presence in the field, they got arrested in connection with this case. There was no there was a case of mob lynching where no proper identification was conducted. Where no proper identification was there, nor any TRP was conducted in that regard. All the petitioners are in custody since last 1 month, and considering their length of detention also, they may be released from bail. Next para. Mr. Goswami Lilane additional people raised objection and submitted that it is a case of mob lynching wherein a 19-year-old boy had to lost his life, and he was brutally murdered by these accused persons along with some others. The witnesses have specifically mentioned the name of these petitioners and showing their involvement in the alleged crimes. He further submitted that several numbers of accused persons are yet to be arrested in connection with this case, which will also unearth some other facts of this. Mr. Goswami further submitted that there is a there was a total, then there was a proper compliance of section 47, 48, and 36 of the BNSS, wherein the detail have been mentioned under which ground they got arrested, which was duly signed and certified by the investigating officer. Mr. Goswami accordingly raised payment objection and submitted that it may not be a fit case to grant bail to the present petitioner at this case. Okay, I'll record your submission. You will go for the case diary. Just follow. Yes. I have recorded your submission. We'll pass the order. Oh.
In the forwarding report also, there is the definite evidence or specific allegation is not specific.
Mr. Ganguly further submitted that there is no definite or specific allegation is also made
regarding the alleged involvement of each of the accused persons.
Forwarding report regarding their involvement in the arrest.
I'm obliged.
Mr. Borwa, itu WhatsApp. Itu kita ya emang mau kalian. Dan itu harus saya bentuk buat itu.
Wait, please, Your Lordship.
What is 3036?
Lordship, the year of the PS case was wrongly written. It is written as Sattawari PS case oblique 2025 oblique 2025 instead of 25 of 2026, Lordship.
In your petition?
Yes, Lordship. That's why miscase was filed for the correction of that year of the PS case, Lordship.
Year of the PS.
Yes, Lordship.
36 to house. Hard Mr. B. Chaudhary, Delaney Council for the petition. So hard Mr. E.P. Delaney additional PP. this I has been filed in connection with BA 1217 of the 2026, praying for correction of the police station case number, wherein it has been written as Sortebari police station case number 25 of the 2025, instead of the correct case number as Sortebari police station case number 25 of the 2026. Mr. Musami raised no objection to that regard. Accordingly, the constable of the connected bail petition number PA 1217 will be read as Sortebari police station case number 25 of 26. But I mean, like, with the about I test. Yes, now come to
Now, Lordship, the FIR Lordship will find on page 36, Lordship, it is a case of Lordship 140 of subsection 3, kidnapping and wrongful confinement, 7 years imprisonment. Here, this petitioner already in jail custody for 26 days, Lordship. The girl already been recovered, Lordship. She has been handed over to her mother, Lordship. That order, Lordship, will find on page 27, Lordship, annexure 5, Lordship. Now, Lordship, what happened? Allegation so far that Lordship they have kidnapped. It is not kidnapping, Lordship. The girl, the petitioner, one of the petitioner having love relation with this Lordship girl, and that girl was in school uniform. On that day, this petitioner Lordship asked her to go to a restaurant to have some refreshment, Lordship. On the way, they met in an accident, Lordship. The poor people, Lordship, rescued them, and Lordship. She could not reply, Lordship, properly. They suspected that it was a case of kidnapping, Lordship. 140 subsection 3, 7 years punishment, Lordship.
So 14 years old girl, active step that is required in this case, so I have to case there.
Otherwise, Lordship, there is no allegation of POCSO anything, only that section, Lordship, 140 subsection 3, Lordship. Since already 26 days, Lordship, considering the length of detention.
tell us one thing, because she is a minor girl of 14 years.
Yes.
So is there any section registered? Section is registered section is 143.
143.
Then subsequently, any added section is there?
Therefore, we have to take instruction regarding.
Huh?
We have to take instruction regarding that person.
No, from CD I have not seen.
No, CD not received yet.
Oh, CD not
not
received. Oh,
Earlier, that's why the case is filed. I was filed. Case number was.
Oh, okay, then why are you submitting, Mr. Chaudhary?
Lordship, since
I
the
thought
girl
CD
already
is
been
the-
recovered, Lordship. that's
Whatever
why-
recovery, POCSO may be there, na?
Lordship, POCSO allegation is
Mr.
not
Beach.
there.
Allegation, how can we know? At the time of kidnapping, she was kidnapped.
Yes, Lordship.
Later on,
subsequently-
what had happened with her, how can we know that? We don't have anything before us.
Lordship, on the
Neither
date
the
of
statement of the
that-
girl, nor there is anything, added section, no, nothing is before us.
Lordship,
na?
case page 27,
No,
the
what is
order
27
reflect, Lordship, it's
says?
a Jima was given, Lordship.
Yes, yes, Jim,
There is no
we are
reflection,
not on
Lordship.
that. We are not on that. We are saying that she is a minor girl.
Yes, Lordship.
At
that
the
is-
time of institution of this case, 140 is there, undoubtedly.
Yes,
What
Lordship.
had happened subsequently to her, because she is a minor? Whether any section has been added, that's what we need.
But Lordship, the
That's what we need. We heard Mr. B. Chaudhary, Dewan Counsel for the petition. Also heard Mr. T.P. Goswami, so she did not receive. Issue reminder. Issue reminder with a direction to the IU to furnish the case diary on or before the next.
Lordship, before Eid, Lordship, if possible, Lordship.
How it will come?
He is a young boy, Lordship,
Yes,
23
yes,
years.
we understand, but how it will come?
It's from Satyabari, Lordship.
It will not come, na, from Satyabari, not come. Satyabari comes.
Let's try, Lordship, before Eid, Lordship, 127, Lordship, if possible, Lordship.
We are
Otherwise-
not missing anything on. Yes,
5th of June.
I got you first of June. First of June.
Okay.
Judicial custody since 1/10/2025. Now it's today today is 233 days. Now, so for the allegations against me, level against me, so for the search sheet is concerned, my lord, the search sheets, the allegations is 3/6, 3 within bracket 6, 3 within bracket 7, 3 within bracket 8, 61-2, 1031, 105-238, 301-2, 318-4, and 316-5 of PN as well. And so far I am concerned, my lord, the charge which has been brought against me are, except, my lord, 359, 36, 37, 38, 61-2, read with 1031, 308, 318, and 238. So far, my lord, section 363738 is a concern. Are general exceptions. My lord, the lordship will find what general exception it says. And 61-2 is a criminal conspiracy. 1031 is a murder. 105 culprit. 105 is a culpable. Huh? So far we are concerned, we do not have 105, my lord. Culpable homicides not amounting to murder. Then section 238, causing disappearance of evidence of offense or giving false information to the screen offender. 3082, extortions. Section 318(4), cheating. And section 316(5), criminal breach of trust.
So basically, you are related with which sections you are telling? 369. You are being charged with, yes? I mean, not charged with, yes.
Yes.
charged with,
So far, these are concerned. 316 is not with me, my lord. Against me.
Okay.
Against me, 318(4), cheating. 308,
Yes.
3082, 238, 105.
105, nice.
Sorry, 105 is not there. 1031.
1031 is also with against you?
Yes, against me, murder, my lord. Because, and 61(2), criminal conspiracy. my lord.
Conspiracy. Okay.
So first of all, my lord, your lordship has to see that whether, my lord, is a homicide or is a case of drowning. Lordship has to see. Now, prior to that, my lord, your lordship has to see whether there is any criminal conspiracy on the part of me for causing death of the Jubin Garg. Now, the prosecutions, my lords, has leveled against me is what? The giving the victim a bottle of whiskey against the medical advice, knowing fully well that it can be fatal. That is number one. Number one is, that means giving a bottle of a whiskey to late Jubin Garg. Not giving Amit Prabha a separate room to stay in, making the cause of drinking to the Jubins by staying with the Jubin and giving him whiskey. Number three, my lord, not informing the organizers of yacht party of the medical condition of the victim. That is number three. Number four, my lord, despite of meeting the managing team of the victim, even the morning of the incident, makes no arrangement for the safety, security, and medical health of the victim, nor inform them to cancel the trip. Next is sends the Assam Association president to the yacht, but did not ask him to cancel the event, despite of public medical advisory of the victim doctor that is an epilepsy patient. Next, making no medical arrangement, and hence the victim missed golden hours to save and was taken in ambulance 75 minutes after the incident. My lord, these are for your reference, my lord. I just giving you this copy. What are the charges level against me, my lord? These are the things, my lord.
Yes.
Now I'll come by one, my lord. Now your lordship will find I am a co-organizer of Northeast Festival at Singapore. Prior to that also, since 2011, I am doing the Northeast Festivals. Not only Singapore, prior to that, it was Vietnam, as well as Thailand, as well as Delhi. In all the program, late Jubin Garg was a brand ambassador to these festivals. Now, this festival, who organized? I was a co-organizer, and it is the ambassador of, my lord, Singapore. And he invited the guests, Milords, in association Ministry of External Affairs, Milords. Now, your Lordship will find your Lordship may kindly take my additional affidavit, Milord. Additional affidavit, Milord. By which the letters of invitees
Like a vanilla. Blue platform. Oh, yeah.
logo line. But before that, I just point out one thing. The only ground for rejection of my bail petition in the trial court is only that I may, if I granted bail, I may abscond or fled away. Madam. That is the main ground on which my bail prayer was rejected. And giving a bottle of whiskey. That is nothing more than that, Miller. Now,
It's by earlier rejection order.
yes, Miller. I'll come for the rejection later on. First, I'll just see how this Northeast festivals, Miller, who organized and what my function is there. And I being a co-organizer, what I have did. Now, kindly see the annexures, these series, Miller, page 89 onwards, Miller. Page 89 onwards. And
Yes.
these are invitations by whom? The High Commissioner of India. To whom your Lordship will find on the, and who are the issuing authority? Dr. So-and-so is the person. High Commission. That means so far the Northeast festival is concerned, though I am a co-host, it is entirely the High Commission of the Singapore. High Commissioner of India of Singapore. Now, in association with Ministry of External Affairs. So, venue, so far the Singapore is concerned, my lord will find. So, number one for my lord, meeting of minds. That means for the venue, my lord. So, Singapore. So, definitely it is that there's meeting of mind has to be there. First of all, with more than one person, my lord. So, number one, the chain which first to attract, my lord, criminal conspiracy is this. Number one, where it has been started. Entire case has been started from the venue itself, where it will be did. That whether I forcibly taken to him or not. Well, it transferred from this G series. And if your Lordship kindly see, it has been sent to different states of Northeast, my lord. Now, subject participant on Assam at 4th Northeastern India Festival in Singapore. So, again, my lord, participation of Tripura, my lord. On the next is, your Lordship, with participation of Meghalaya and participants of Manipur, my lord. Participation of Sikkim.
Different states of Northeast.
Yes, my lord. It's all entire Northeast, my lord. Participation of Nagaland, who issued? These are all issued by the High Commissioner of India of Singapore, my lord. High Commissioner of India of Singapore, my lord. Then, my lord, if your Lordship kindly see, then annexure E, the confirmation by the Arunachal Pradesh. As a reply to the letters, I am writing in response to your DO letter number so-and-so, so-and-so. Your Lordship will find at page 95 annexure E, my lord. I am writing this in response to you, your DO number so-and-so, in connection with participation of Arunachal Pradesh at 4th Northeast India Festival in Singapore. We are pleased to inform you that the Arunachal Pradesh will attend 4th Northeast India Festival on 19th of September 2025 in Singapore. We are happy to confirm participation of our Honorable Chief Minister Shri Pema Khandu and our Deputy Chief Minister Shri Chawna Min, along with the delegation of 62 members, including Honorable Ministers, members of our Legislative Assembly, officers, entrepreneurs, traders, and cultural troops from the states. So that is a confirmation status. Now, next 96 Annexure F, Miller, by Dr. Silpak Ambule, to address to Sri Neelam Sumi Rao, Secretary, Minister of Texas, New Delhi. So I am writing to you regarding 4th Northeast festivals, which are planning to organize in Singapore from 19 to 21 September 2025 with participation from all states of the Northeast India as we celebrated 60th anniversary of India-Singapore diplomatic relationship this year. NEIF would be a timely event and highlighting the rich culture of the regions and focus on the potential trade, tourism, and business links between the region and Singapore. We'd like to invite you to attend the inaugural session of the Northeast Festival, so-and-so. We are also inviting the Honorable Donor Ministry, Secretary, Chief Ministers of all Northeast states to attend the inaugural functions. So, my lord, these are the letter which has been issued, my lord, and that is at Annexure 5. The others are, my lord, I will not go the entire this thing. So, while they're confirming their attendance, my lord. Now, your lordship will find next, that is at page 98, my lord. Now, kindly see. So, for the organizer concerned, it is, yes, I as a co-host in association of High Commission of Singapore, of India and Singapore, in association with Ministry of External Affairs. I host it, I arrange all these things. Now, in this context, Millard, he being the brand ambassador, Millard, I invited him for a short program, Millard. While I invited Millard, and I have arranged an accommodation in a 5-star hotel. That is Pan Pacific, Singapore. Now, your lordship will kindly take page 98, Millard. Is a mail sent to the manager of Pan Pacific, Millard. So-and-so, dear Siddharth. Siddharth is not Siddharth Sharma here, the accused, is the manager of the Pan Pacific, Millard. Breakfast is complimentary with all rooms. We can pay maximum for 4 buffet meals to the rooms taken as by during the stay of the guest. If they take a buffet everything else, they have to pay directly. Nothing else unless specifically instructed by us in the email. We have Jubin, one of the India's biggest influencers. He has strong influences in Singapore. Also, he has sung more than 30,000 songs in Hindi, English, Assamese, Bengali, and other than the Indian language, and in an icon of India. His stays in putting one of the good words about the hotel will really help the hotel. He is frugal eater. We would request the hotel to provide complimentary food. My lord, that is very important, and in bracket, my lord, kindly see, no liquor drinks to him during this stay. What I stress on this, I have informed that these are the things, please do the so-and-so, we'll bond the expenses, no liquor. Kindly take note of that. Now, there is another, my lord, allegations against me regarding giving Amrit Prabha in the same room, my lord. Page, your lordship may kindly take up page 99. Now, if your lordship kindly take page 9. These are list guests, my lord. Number 6 onwards, my lord. Kindly, your lordship got it?
Page?
Page 99. The list because there's an allegation regarding me that I have arranged Amrit Prabha to stay in the same room. So this is a guest list. These 4 rooms, there are 5 persons. Your Lordship, kindly take note of 5. There are 5 persons from going here. Who are going, Milord? Zubin Garg, Amrit Prabha Mohantas, Shekhar Goswami, Siddhartha Sama, and Sandipan Garg. These are our 5 persons. And rule in Pan Pacific was 4 rooms. 6 from serial number 6, Your Lordship will find Zubin Garg. 7, Zubin Garg. 8, Zubin Garg. And crew, Milord. Number 1, Your Lordship, can you see? Number 1 is Zubin Garg, the single room, Milord.
Where number 1?
Yes, number 6.
Number 6, Zubin.
Number 2.
Hmm.
Next, Milord, Zubin Garg crew.
Hmm.
Name upon arrivals.
Hmm.
Zubin Garg crew. Zubin Garg crew. Name upon arrivals. So therefore, Milord, Your Lordship will find that we have what the allegations against me, we have so and so. It's not that we have provided a single room of Zubin Garg, Milord. Now, apart from that also, we have booked another room, Milord, in nearby hotel, Milord. Suppose if you have any uncomfortable, please be there, Milord. Annexure, that is page 102, that is annexure I, actually. I, Milord. Village Hotel Bagis for Paris Hospital, Singapore.
No, by showing this 99, what do you want to show? That ones from 6,
No,
Zubin
what?
Garg,
Because
6, 7, Zubin Garg crew,
True,
8 and 9 also Zubin Garg crew.
true. And one first is 6 is Zubin Garg, Milord.
Yeah, Zubin Garg.
That is single room. But he is now on arrival. Who was the
So
person?
from where the main allegation that you have not provided an extra room to Amrit Prabha and he was supposed
Yes,
to
yes,
get
yes,
allowed.
yes.
Yeah, where from
That
you
I have what my allegation is. I have accommodated Amrit Prabha with Zubin Garg.
Yes.
That is it. So I want to say that it's not that. We have 4 rooms in Pan Pacific and another room nearby a hotel, Milord.
And the
What it shows, first is Zubin Garg, then Zubin Garg and crew on name upon arrival. We do not know who are the person are coming along with the Zubins. So that is why this has been given. I was not, when there's a check-in, I was not there. They have done accordingly as per their wishes, Milord. Not my wish, Milord. What I want to submit before your Lordship, Milord. Now, apart from that also, if you have any difficulties, there's another room has been booked in the name of your Lordship policy. 2 guests, annexure I, that is at page 102. 5 guests, MS Siddhartha Suma plus 1. So therefore, your Lordship will find there are 5 rooms.
Yes.
Now, this is number 1, Subhada giving a room and not allowing Amrit Prabha staying with so and so. I have shown it from the records. And I have shown that there are no liquor served. I have specifically, and I have said that he was a great singer, having sung more than 30,000 words. Now will come that how it's happened on what is the from 16 onwards, when he died, the people has been called. Those who are person take the SIT team has taken their statement. What has happened on 0 to 17, 16, 15, what has happened? Kind of how he has died and what my role is there. Now I'll come, my Lord. Though, my Lord, your Lordship is hearing on bail, my Lord. these are the factors which has to be taken into the consideration for deciding bail also. That whether my involvement, so whether the conspiracy is concerned, my lord, whether I have a conspiracy or not, that has to be looked into, my lord. Number one, I have seen that regarding venue, whether there is a conspiracy in holding Northeast Festival at Singapore. And my lord, my lord, forcibly has taken him to there. My lord. Now, whether I have taken a forcibly or not, your lordship, kindly go. He has a listed witness 87. He is Mr. Tanmoy Fukuan, my lord. Page 110, my lord. Your lordship got it? I just read slowly, my lord, so that your lordship can also go through. That he is a Tanmoy Fukuan. He was listed witness as 87, my lord. After receiving the Northeast Festival program agenda shared with Assam Association WhatsApp group, I messaged, my lord, your lordship kindly say, I messaged Jubin Garg, Siddhartha Sama, his manager, on 31st August to check on his availability. Who? Tanmoy Fukuan, my lord. Kindly see. Late Jubin Garg messaged back that he will be in Singapore on 17 to 21. So and so, he called that evening and we spoke for 5 minutes. He said that he was not very keen to visit Singapore as he was busy with, well, Lordship kindly said busy with release of upcoming movie Roy Roy Binale. But my lord, here your lordship will kindly say, but he must be there because it is his version, my lord. Because he is the brand ambassador of the event. So that is the Tanmoy Fukuan. Now, he informed me that he has only a short performance at Northeast event, required to perform only 2-3 songs, and told me to plan something fun, my lord. This is very important, my lord, your lordship. This is Tanmoy Fukuan's statement. What he said, that I will perform only 2-3, and he said, and told me that to plan something fun, my lord. What does it mean for fun, my lord? It is a statement, my lord. He said that he has not even explored as the Singapore much and would like to go around. I asked him what his preference are to do in Singapore. I said, as you know, Singapore is well known for city tours. Zubin said he doesn't like to city tour, but would like to go close Nasser or to rustic village environment. I said we have option there by nearby island of Malaysia and Indonesia, my lord. It is his wish, my lord. It is not my wish, my lord, to arrange for so and so. Now, kindly see, he further added that Shekhar Goswami, his musician, his co-singer Amrit Prabha and his cousin Sandipan Garg will accompany him in Singapore too. And he has communicated to Tanmoy Fukuan that who has been accompanying with him. I messaged Garima Garg and Parthajuti Goswami separately if they will have travel to Singapore. Both Garima and Partha said that they will not travel. On 5th September via WhatsApp, I shared the option of Malaysia, Tioman Island, stay for a night in case they have a multiple visa entries. Zubin called twice, my lord. Next, that is on 17th September, my lord. Lordship, kindly see. On 17, he reaches in Singapore, my lord. Zubin called twice at 1:30 a.m. Singapore time. I missed the calls, so he left a message that they have an 8:45 a.m. flight on that day to Singapore from Gauhati. I said I will be there to pick you all up. I called Siddhartha Sama and informed that I will be at Singapore airport to welcome all. I had the number since 2016 as his earlier help coordinate Jubin Garg, Zubin, Garima and the teams busy to perform in Singapore. Now, I booked a rental car for 3 days and went to the airport in the afternoon. Zubin and the team landed at Singapore, Changi Airport, 17 September via Druk flight Singapore at Terminal 3 around 3:30 p.m. Upon reaching Singapore, there was a small welcome event at the airport. 7 members, Lordship, kindly take this, including me, of the Assamese community, Indranil Goswami, Reza Goswami, Debojiti Hazarika, Abhimanyu Talikdar, Dizendra Nath Goswami and his wife. This is the first time I was meeting Amrit Prabha Mohanto in person. Siddhartha Sharma, a member from the event organizing team, asked us to head to the Pan Pacific Hotel, Singapore, which was about 20 to 25 minutes away from the airport. Accompanying us on the way, the car park was Debojiti Hazarika Secretary so-and-so. I asked Siddhartha if he want to be with the late Zubin Garg together in my car, but he said that drop Zubin Garg and co-artist Amrit Prabha Mohanto to hotel only. My lord, these are not my plan. Siddhartha Sharma, Sandeep Garg and Shekhar Goswami took other cars organized by the so-and-so for Pan Pacific Resort. Late Zubin Garg, my lord, your lordship kindly see, once he reaches, my lord, I'll come from where he started having alcohol, my lord. Late Zubin Garg consumed Genesis stout beer in the car on the way to the Hotel Pan Pacific. He started having drinking also from there itself. I was driving and late Zubin Garg was seated in front of the seat while Amrit Prabha sat at the back. On the way, we had many casual chats about the current podcast scenario of Assam, including Gorima Bo's podcast, his participant in the so-and-so. Zubin Garg had 2-3 sips of the beer. The next day, upon cleaning the car, I found he consumed only 20% of the 500 ml can. Upon reaching the hotel, we were at the lobby and Zubin teams were checking it to get their room entry cards. At the lobby, I met organizers and got introduced with Syamkanu Mohanto, the organizers and owners of the so-and-so, and also met his wife. I do not know them personally at all. A while later, late Zubin Garg having a drink with Syamkanu Mohanto. This is what he says. I am having a drink with so-and-so at the hotel restaurant lounge. In the meantime, my attention got diverted when I bumped into ex-colleague at the hotel lobby. After joining Zubin, the restaurant lounge, he asked me, and he said, what the exciting things that we can go on 19th September. I shared the option again. Indonesian islands, Batam Bintan is likely 40 minutes by ferry to visiting Tioman, including road trips and the ferry to the Tioman Islands. But both options will need at least one night stay to make the trip worthwhile. I then added that in the past, I have participated in the several yacht trips that took us to the southern Singapore of the southern island of the Singapore, one of which one of the artists from the Assam, Anurag Papan Mohanto, was in 2010. Zubin Garg was very enthusiastic after hearing about the yacht trip idea. The idea is not by me, my lord. It's by this association, my lord. If, my lord, I have a mansria or meeting of minds, definitely. Tanmoy Phukon are also to be added as a, my lord, by adding, my lord, criminal conspiracy, my lord. The trip was not been booked by me and has been arranged by not by me, my lord. Late Zubin Garg, my lord, after hearing about the yacht trip, but I told him that I can let you know after checking the available options because I have never booked a yacht before. In addition, I need to get a few fans who are interested to join and share the cost of the booking. A yacht is very expensive. Soon after, Siddhartha Sharma, Shekhar Goswami, Sandeep Garg and myself escorted late Zubin Garg to his room. On reaching the room, so-and-so, I heard the voice of woman inside. It could not be, it could be so-and-so, but I did not specifically ask about them. Around 7:30, I guided Siddhartha Sharma, Shekhar Goswami and Sandeep Garg, asked to walk around the Marina Bay Sands. They took photo near the Maryland statues. At that time, I asked Zubin as to how the things are going on with him, as I was curious about the meeting him after so many years. Shekhar then immediately responded that, just I will not, I skip this line. Your lordship may kindly read this line. Zubin is always so-and-so. I skip.
Okay.
Siddhartha Sharma asked me for shopping tips, so-and-so. So I've just skip all these things. I don't require all these things. Your Lordship kindly see that while going to the clerk way, brave Lord, he found that how it is happened, and he has stated these are the things.
Okay.
Now your Lordship will kindly come to uh, 122 first, my Lord. 120, the last part, my Lord. That is in bold, my Lord. I call Abhimanyu Talukdar and invited him to join yacht trip as we were able to accommodate more. He said he must attend ACI meeting. He said that he must attend High Commission of India meeting on 19 and may not be available. He added to check with Chamkana Mohanto as Zubin is an invitee for festival and has organized it, and it doesn't look good to take him away for another engagement. He may require for ACI meeting. Then I called Syamkanu Mohanto to check when the Subin Guard needed to be back for the Northeast festival program with the ACI. The following day, I said some of the Assamese community members want to take him out for a yacht trip. Syamkanu Mohanto next, my Lord, Mohanto mentioned that it starts at 7 p.m. and Zubin need to be there as he is the key person, my Lord. My Lord, kindly see my conduct, my Lord. Now, when they have arranged a yacht party and it has been Tanmay Fukan associated and said, I do not have to say anything about what they have planning, my Lord. I say that, kindly see that there is a program, my Lord, will start at 7 and he has to be there because he is the brand ambassador, my Lord. Without him, my Lord, this function will be, my Lord, meaningless, my Lord. He did not say no for Jubin to be giving there a yacht trip with Assamese communities. Now, I skip next paragraph. Obimanyu confirmed to join the trip. The program was to move forward. I agreed with him to have buffer of 90 minutes and plan to cut short of the yacht trip, ending time to 5:30 p.m. instead of 6 p.m. Considering Zubin needing time to change for ACL program and there is a traveling time too, Obimanyu took responsibility to bringing back Zubin for the ACI program as both were invited. Now, who are this thing alert? Obimanyu took the responsibility. I will take to the venue with him. In the meantime, I recommended in our WhatsApp group to have bring only, my dear Lordship, kindly see this statement is a very important statement by Tanmay Fukan. They have a WhatsApp group, Miller, the Assamese Association. And what they say in the WhatsApp group, in the meantime, I recommended page 125, Miller, your Lordship will find. In the meantime, I recommended in our WhatsApp group to have bring only basic alcohol, beer, not hard drinks. As Zubinda needs to be present for a formal occasions of meeting of ACS program on the night. They have planned, all the members who are accompanying Zubin Garg in the yacht party, they say through WhatsApp, please bring the beer, not hard drink. I also mentioned the team to bring their own food and drinks. And we are not buying anything from the yachts and it is expensive. After waiting a few hours, Zubin and his team came down to so and so. I just skip this one. It's not necessary. Your Lordship may kindly come to 126, my Lord. Second para. We discussed logistic of the yacht trip. I said we will be dressed in white outfit, which is typical of a yacht trip. I told Siddhartha and Sandeepan to bring swimming trunk if they want to swim. Every member will bring their own foods and drinks. Food and drinks. Siddhartha Sama said they will also bring their own food and drinks too. Late Zubin Garg fell in love with music, so I just skipped, Miller. Now come to your Lordship will come to 127. 7 Miller. Very good. I skip, my lord, that is on 19th September, my lord. What has happened on 19th September? My lord? So, Lordship may kindly come to, my lord. Last para, we took, that is, that on that, what has happened on 19th, my lord. We took the yacht with 17 members, including 11 members from the Singapore and 5 from Jubilee, plus crew members at 2:10 Singapore time. I simply amenities briefing the so-and-so. Then the yacht sailed for about 30 to 40 minutes until it docked at about 100 meters away from the Lazarus Island. During this 30-40 minutes, at one point of time, we reached the front deck of the yacht and opened our food and drinks packet. Zubinda chose to drink beer. I saw him having only 2-3 sips. The pork was consumed by the most of us, and there was nothing left. People took photo and videos. Now, coming to the last paragraph, Milord. Zubin appeared to be from behind wearing this long short and said he would also like to jump into the water. Finally, these are very important things, Milord. This Lordship has to be taken into consideration, Milord. Seeing this, I helped him wear a life jacket. Tanmay Fikar helped him to wear a life jacket, Milord. He jumped away into the water instead of landing on the flat float where he was supposed to and did a small round. He then realized that the jacket was loose and uncomfortable for him, so he removed it in the middle of the water. Well, he removed it in the middle of the water, my lord. Then he swam back to the boat deck. Seeing this, the captain of the ship asked me to make sure he wears a jacket. From the deck, he then said it is easy to swim in the sea because salt water is buoyant. He boasted by saying that he taught Shekhar and Siddhartha to swim. Zubin sat on the deck next to me and I was holding on his left hand and was not wearing a life jacket. I tried to put the life jacket around him twice. I said, it is a protocol here in Singapore, but he refused to wear and it pushed it aside. He said, I have never worn this before and I don't like it. He seemed unhappy with my request. In a matter of few seconds, to my surprise, he jumped again into the water and started swimming very fast without the life jacket, Milord. He jumped on his own without a life jacket. In spite of that, Tanmay Fukan said that, yes, it is a protocol in Singapore. You have to order, no, I don't like to have this thing. Then he jumped in. I come last portion, Milord, that is in bold, Milord, what it has been written. He went about 50-70 meters and suddenly what I saw was that his face was down and he was not swimming and asked Shekhar if everything is all right. Shekhar gave me a thumb up signifying nothing was amiss. Shekhar and Debojiti turned him around and lifted her face upwards. I saw food spilling out from his mouth. Upon seeing this, the captain plunged into the sea and helped bring Zubin Bagh to the deck after the pulling him, leaning along the kayak body. It took 7 to 10 minutes to bring him into the deck. CPR was administered by the Sandipan and the crew member and the emergency service was activated by someone. He was unconscious but warm as I felt his palm. Someone saw he was clenching his teeth with tongue and in between, and Rupkomal Kolita forwarded me a tongue to separate the teeth apart. Within about 15 minutes, Singapore Civil Defense Force reached the spot on the Coast Guard and started the CPR process again. All members of the ferry were taken to the Marina South Pier, where emergency service were on the standby. I saw them inject the saline water, drip, and machine CPR. Zubin was then taken to the hospital in a stretcher. We are then ferried back to the same yacht, keeping Marina so-and-so. Now, my lord,
Reading the whole his interrogation, you're going to read.
my lord.
His entire evidence you're going to read, or I'm an interested friend.
No, no, I'll just skip now. I'll skip this one. Because,
What is important for you, just.
my lord.
Yeah. Okay, then showing this, you want to show that
My
you are
lord.
not present in the yacht party and nor it was
First
organized
of
by
all,
you.
neither I am a party, I am the party to the yacht parties, my lord. I was not present, my lord. And so far the golden hours is concerned, means I was away, I was in a meeting there. I was not in a. So golden hour, my lord, whatever did, my lord. So but Singapore is a very advanced country, my lord. What your lordship has, CPR, whatever these things, they come immediately. This from going from this island to there, it will take around about 60 to 70 minutes, and thereafter immediately shifted. So for the golden hours, so for my involvement regarding that, for taking advantage of these golden hours, what is been stated, my lord, what negligence I have, what I have did, my lord, nothing, my lord. It is not at my wish, not at my will, my lord. The yacht party has not been organized by me, my lord. It is by the so and so. I don't know why prosecution has not made them an accused, my lord. I don't have an answer to that, my lord. If they brought with the allegation of conspiracy, criminal conspiracy, they are the person, my lord. They have to be a party to that. The why don't know, I don't know. Reason based known to the prosecutions, my lord. Now, my lord, অভিমান্য তালুকদার, my lord. No, my lord, he is also there, my lord. They are the eyewitnesses, my lord. These are the person who are who Obimanyu Talukdar, Stanmoy Fukonada, are the eyewitness and who arranged this your party. And here your lordship will find these others are nothing, my lord. Most of the people, any Tom, Dick and Harry will come and give a statement, so and so, I know so and so, these are statements which has been given. But in fact, these are the person who given the actual fact of the case. My lord, 147, 149, my lord. One 148. Well, what I just want to stress upon this one, the last 4 lines from the bottom, my lord, page 148 of, my lord, I have annexed listed witness 93 of Mr. Obimanyu Talukdar, my lord.
He is Obimanyu.
Obimanyu. They are the present, my lord. Obimanyu, my lord. 148. I will not go entire statement which is made. Relevant portion, my lord. Late Jubin Garg, my lord. 148. Last para. 4 lines from the bottom. Late Jubin Garg took 1 peg of Macallan whiskey. He was also accompanying with this person 1 peg of the. I took 1 shot too. It was paid by Porikit. Because from the day onwards, he is having, because he is an alcoholic, my lord. Now he used to take from the day when he boarded the plane. I'll show. $149. Your lordship get to know that what has happened in a year, how he has jumped in, so and so. I will not say the same thing has been said by this also. 149 of the last paragraph that is in this thing. I saw late Jubin Garg holding a can of Genesis stout. Okay. Stout beer. This is a stout beer. I did not notice him drinking as I was far, but he must be having taken some from the can. Now, kindly see 150, page 150. I just 1 paragraph, my lord. Last paragraph. What has happened? Then I saw Jubin Garg, last paragraph, ready to shorts and in a life jacket. He went into the water wearing the life jacket. He swam for about 10 minutes and came back. Somebody said his life jacket was oversized. He took off the life jacket. In the meantime, Devojyoti and Siddhartha Sharma went on the kayak. I heard the captain shouting that this person, meaning late Jubin Garg, must wear life jacket. Now, your lordship will. A smaller life jacket was passed on. I saw Tanmoy trying to get him to wear the life jackets. Then I saw late Jubin Garg was jumping into the water without a life jacket. The same thing has been reiterated, what Tanmoy Fukan has stated. Now, 152, what has happened, my lord, thereafter? This is the golden hours, my lord. What it has been said by the prosecution that I have missed the golden hours. Now, they reached the yacht about 10 minutes or so. Late Jubin Garg was brought to the upper deck. It should be upper deck, I think. And everybody was around him. The captain immediately performed CPR. Siddhartha Bora passed me his phone when it got connected with the Coast Guard police. I spoke with them and gave them a ship member after checking with the yacht assistants, since it would be take to the Coast Guard a bit time to reach us. We decided to go to a nearby yacht to see if there are any doctors on the boat. It took a few minutes to remove all the inflammable from the water so the yacht would move. I went to the flybridge to shout at one person on the other yacht in a jet ski, asking if they had a doctor on a board, and signaled they did not. Around the same time, we saw a coastal guard boat coming. The jet ski persons speed off to help them identify the correct boat. The boat arrived and docked alongside the yacht, and 2 policemen arrived. One policeman took over the CPR from if I remember correctly, Sandipan. One policeman went up to the fly bridge to guide the captain, while other continued to performing CPR. Yacht sped to the Marina Southwire, where medics and ambulance were waiting, escorted by the Coast Guard boat. By the time we reached Marina, it should be around 4:30 p.m. So this is the actual fact of the case. Now, where I am, whether there's any material to show that I had a conspiracy with so-and-so, leading him death, whether the accidental or homicide, it's an accidental death, my lord. From the statement onwards, to the listed, it's not a homicide, my lord. My respectful submission, my lord. Now, the court support. My lord, just the Secretary Kuswami's statement was there. Why I am saying that he has been having an alcohol from the 17th morning night itself till 19th minute. Kindly see the statement of that is at page 157 minute, Annexure M. That is a translated copy, but your lordship will, because there are the vernaculars also, I'll go with the vernaculars. I'll not bother it, my lord, in whole things, just few lines, my lord.
157.
164. 164. That is 164 is a vernacular. Translated copy, I will not go for the translated copy. Now, your lordship may kindly take 169. 169. Others are how he has been associated with Jubin Garg. It's not relevant, my lord. How he has started studio, what he has to done, that's not relevant to us. But relevant to us is the 17th, what has happened on the 17th. From start, going from here from 8:30 morning, reaching Singapore, And thereafter, 17, 18, 19 million. And 19 he died. Day 1, my lord, that is on 169. ৰাতিপুৱা 6:25 সিদ্ধাৰ্থ আহিছিল গাড়ী লৈ মোৰ ঘৰৰ বাটলৈ মই ওলাই আহিছিলোঁ গাড়ীখন তাৰ ভায়াকে চলাই আহিছিল 6:45 মানত এয়াৰপৰ্ট পালোঁ মোৰ পাছপোৰ্ট আৰু ভিজা সিদ্ধাৰ্থৰ লগত আছিল সি মোক গাড়ীত সি দি আছিল আমি দুইটা এয়াৰপৰ্টৰ ভিতৰত সোমালোঁ ভিতৰত অমিত প্ৰভাক লগ পালোঁ লগতে শ্যাম কানু দাদাৰ টিমৰ দুজনকো লগ পালোঁ তাৰে এজন জয়শ্ৰী বুলি পিছত গম পাওঁ 20 মিনিটৰ পিছত জুবিন দাদা আৰু তেওঁৰ লগত থকা PSO বৰাদা আৰু এজন ব্যক্তিৰ সৈতে এয়াৰপৰ্ট আহি পালে জুবিন দা ডাইৰেক্ট সোমাই অহাত এজন CISFে দাদাক বহিবলৈ দি বাহিৰলৈ ওলাই আনিছিল দাদাক অলপ নিচাত থকা যেন লাগিছিল অকমান সময় CISFৰ জনৰ লগত তৰ্ক হৈছিল দাদাৰ পিছত এয়াৰপৰ্টৰ ভিতৰত দুই এজন মানুহে বুজাই মেলি দাদাক ভিতৰলৈ আনিলে আৰু ময়ো দাদাক হাতত ধৰি লৈ আহিলোঁ টিকেট কাউণ্টাৰৰ ফালে দুই এজনে তাতে দাদাৰ লগত ফটো উঠিছিল 20-30 মিনিটৰ পিছত আমি গোটেইকেইজন সোমালোঁ আৰু চিকিউৰিটি চেক্ৰেটাৰী ইমিগ্ৰেশ্যনত ৰখিলোঁ 15-20 মিনিটৰ পিছত আমাৰ ইমিগ্ৰেশ্যন হৈ গৈছিল ভিতৰত সোমোৱাৰ পিছত জয়শ্ৰীয়ে কৈছিল এখন চবেই মিলি ফটো উঠাৰ কথা সেইমতে ফটো উঠোৱা হ'ল তাৰপিছত ফ্লাইটত সোমালোঁ চবেই নিজৰ নিজৰ চিটত বহিলোঁ জুবিন বাবা অমিত প্ৰভা আৰু জয়শ্ৰী এটা চিটত বহিছিল মই সিদ্ধাৰ্থৰ সন্দীপৰ আগফালে বহিছিলোঁ ফ্লাইট টেক অফ কৰা আধা ঘণ্টাৰ পিছত দাদা আহি সন্দীপৰ লগত আগফালে বহিল আৰু আমাৰ গোটেইকেইটাৰ লগত ৰৈ ৰৈ বিনালে ফিল্মৰ কথা ক'বলৈ আৰম্ভ কৰিলে দাদাই বহু কথা কৈছিল লগতে কৈছিল যে 21 তাৰিখে আহি ছিংগাপুৰৰ পৰা 22 তাৰিখৰ পৰা তেওঁ ৰৈ ৰৈ বিনালে ফিল্মৰ বেকগ্ৰাউণ্ড স্ক'ৰ বনাব দাদাই ৰিলিজ নোহোৱা তেওঁৰ চিনেমা নতুন ভিডিঅ' আমাক চবকে তাতে মোবাইলত দেখুৱাইছিল তেনেতে এয়াৰ হোষ্টেল আহিছিল আমাক কিবা খাবলৈ দিবলৈ ড্ৰিংকছো এভেইলেবল আছিল দাদাই ফুডজৰ লগত ড্ৰিংকছো লৈছিল খানাটো কিন্তু খোৱা নাছিল কেৱল ড্ৰিংকছে খাইছিল জাষ্ট what he did in the morning it was clear from the statement I'll not go up more than that কিন্তু খোৱা নাছিল দিছে বহুত দেৰি কথা পাতি দাদাই অলপ শুব পিছফালে গৈ খালী চিটত শুই গ'ল But what I want to say that on 17th he started the alcohol from the morning itself landing at Singapore also have it so it's continuing he's just habitual drinker alcoholic now Lordship has to say what my involvement is there have anybody said that it is because of Shyam Kanu forced him Milord now what has happened how they have made the case Milord my learned friend will definitely say that so and so has said that if we do not go I'll commit suicide my learned friend will definitely stress on that by showing somebody's statement Milord that is only plea nothing more your Lordship kindly see entire the statement the communication between Jubin Garg and Tanmoy Fukonde the other it says that he'll happy be there he want to make a fun of it and it is as per his wish not a single statement against me Milord regarding Malot forcibly taken to the Singapore that is number one so for the golden hour is concerned your Lordship kindly see what in the golden hours I was not there Milord and everything has been given including CPR the police came everything is came doctors came giving a CPR the police is also started giving a CPR Milord number 2 Milord now I'll not go entire this thing Milord now your Lordship will kindly see there's another statement I have just annexed for one thing Milord that is Partha Goswami now he is also accompanied also he is a listed witness 165 Milord just in page 191 Milord your Lordship may kindly what I want to show what Partha says he's a colleague and a drummer Milord for second paragraph Milord just one paragraph I will say I always used to snatch his glass as I did not want him to drink alcohol before shows it is not he was not in Singapore it was earlier to that I do not consume alcohol, so I won't be able to name the brand. I have seen him to drink black and white. Like, he doesn't know the brand name, and he said, I saw him just black and white, Jack Daniels. These are the name of the brands. No. No, what he said that I do not know the name of the brands of the brands of whatever, but he said everything. That he drink black and white, Jack Daniels, and I do not know much what brand he used to drink. He used to drink about 2 packs and get booze soon. He never fell down getting booze, and you say, tiger never falls. He used to take sadha. What he used to take sadha also, Milord. Everything has been. I will not go at that things, Milord. These are things what I want to say, that he is an alcoholic and he cannot live without an alcohol. If I wish, Milord, being, my Lord, having an age of 52 years, if I said I'll have, can you stop me? If I go and have a sadha, can you stop me? You cannot. Has it been a minor, that's a different thing, Milord. Now, I'll just, the ground, these are the things, Milord, regarding that whether murder is attractive to me, whether I is a part of the conspiracy or not, whether I supplied up drinks or not, for doing to causing him death. Now your lordship has to see whether the death was a murder, is a homicide or accident. Here, from the statement which their witnesses clearly shows, it is an accident. Yes, there may be a negligence. Now, Tanmoy Fukan has requested a 2 days, but he doesn't care about that. I am not that. He jumped it. Is it negligent by me? That cannot be. It's a Tanmoy Fukan, my lord. And he's a witness. Interestingly, my lord. Now, my second leg of argument regarding, my lord, that if I granted bail, that I may flee away. That is what, my lord, why the learned trial court has rejected on the ground that I have supplied so and so. And second is that if I've been granted bail, then I may flee. Why? Because I didn't cooperate it, and I flew to Malaysia, my lord. And that is why lookout notice has been sent. That is the reasoning which has been cited by the trial court. And trial court is totally, my lord, overlook these matters. Kindly see this, not my documents. Why lookout notice has been given and who give it? That is not prescribed under BNS or BNSS or CRPC, nothing, my lord. It is the police to give a lookout notice to the immigration to know the entry and exits of the person if he is accused of an offense or he is suspected to be doing something illegal things. Now, why lookout notice and how lookout notice has to be given, my lord? Your lordship may kindly take J, annexer, my lord, 104, my lord, page 104, my lord. Now, this has been mail sent to me, calling me to Gauhati, my lord. By the IO, that is Roji Kolita, my lord. Now, to reply to that, what I have said, last part, my lordship, thank you, madam. Is a kindly see first, notice under 179 BNS has been attached here with for your information and needful. Regard so and so, so and so. I'll come to the 179 BNSS, my lord. Come first. What my reply is this, my lord. Thank you, madam. I would like to come and appear before the CID inquiry team. My bank account has been frozen, my lord. My daughter, Rengoni Mohanto's account is also frozen. I would request government to unblock my daughter's account so that necessary ticketing and other logistics can be done for the trip with regard so and so. Now, kindly see, the notice of witnesses, notice, my lord, this 169,
179.
179. To Syamkanu Mohanto, so and so, so and so, in exercise the power, so and so, so and so, so and so, hence, but para. It says, you are directed to appear before undersigned, Dr. Roju Kolita, so and so, CM Vigilant, IO, so and so case at 11 a.m. Lordship may kindly take note of the time, my lord. Because he has said that I have not cooperated and I have fled away. Because lookout notice has been sent. What has been stated? At 11 and on 6th of October, my lord, 2025, my lord. What is the time given, my lord? 6th. It's a document by them only, the Rodi Kolita, the IO, my lord. Is 11 a.m. on 6th. That is on 26th of September, my lord. And we replied on 28th, my lord. Now, next, my lord, lordship, kindly see page 106, my lord. Now, they said that lookout notice has been sent because I have not been cooperating. I said that my entire account has been frozen. Please open an account of mine so that I come up. With reference to next is 106, my lord. With reference to your email letter so-and-so at so-and-so as directed, will facilitate your ticket from the travel agents, the expenses of which will be incurred upon your arrival. Provide a copy of your passports. And for booking the ticket, Srimati Rangani Mohanto may email bank account details with KYC details so-and-so, so-and-so, Dr. Roji Kolita, so-and-so. Then I reply to that, Madam, this is reference to our discussion. We'd like to cooperate wholeheartedly with the CID investigation. We'd like to travel tomorrow by evening. That is on 29th, my lord. 29, I said, evening from Singapore, preferably Kolkata or Delhi, whichever you deem fit. We would also, for foolproof security, as we are getting message after message threatening to kill, we need ticket for me and wife. So accordingly, my lord, on the basis, I landed here at Delhi. From there, my lord, I have been taken, I have been arrested. From there, I'll say, where is the question of lookout notice then? I don't know from where this lookout notice come into play. Why lookout notice has been given? If I evading, my lord, I am not complying the orders or summons, my lord, issued by the agency, my lord. Now, he has said that lookout notice has been sent. I have fled to Malaysia, so-and-so, so-and-so, so-and-so. So because of what? This is this thing, and I have come. Had it been I want to flee away, definitely I will go to Malaysia. From there, I will go to different things. So that's what I say, that what learned trial court has stated is not absolutely illegal. It cannot be. You have directed 6th. Okay, fine. I didn't appear on 6th. I do not cooperate it. That's a different. Then definitely it will be a different thing, my lord.
This one is gone slow for 10 minutes.
Oh, that's
Anyway, no issue. Just come.
well. No, I'll not take that. Now, in view of that,
Okay.
my lord, I submitted passports. I submitted my Aadhaar card. I submitted my PAN card. Everything whatever I possess, I have given to the IO. And you see my conduct first. Now, if I am enlarged on bail, can I flee away without these things? No passports. I am not a Superman, my lord. I can fly away from here without passport. How can I go? Passport is with them. My Aadhaar is with them. My PAN card is with them. What left, my lord? So that these are things has not been considered by Nana trial court, my lord. Now,
So
that is, now I'll
is,
come to
that
the
is
law,
the-
my lord. I'll come to
no,
the law.
just a second. Your points under which you got, I mean, your charge against you is the one whiskey bottle giving Amit Prabha, you have already right? Not informing the organized party that you have already, and despite meeting, okay then. President. So cover you all the.
Yes, I have covered everything, my lord.
practice.
What our level your lordship has already now. So with the law point is concerned,
Okay.
now whether I am entitled for a bail or not, my lord.
Yes.
Seeing all these documents, my lord, whether I am entitled or not. Now, first I'll finish with 10-15 minutes.
Okay, that too, we'll see. We'll do. It is already 1:05. Finish it at 2.
My lord.
10-15 minutes at 2.
Yes.
Then
My lord.
The only thing is that I will take 3 to 4 hours.
Oh, boss.
So it will not be possible for me to complete today. So at one go on Monday, I will start and finish it off. Because I have to show a lot of documents. And I have to place the church seat. I have to place various materials to make out our case. Or any other date, Lordship, it is convenient.
then can we do one thing?
Let him
Because
finish
it
everything
was a
today.
request to the registry to list less numbers of matters today because of this
Yes.
case only.
Right.
So Monday, same request, maybe a bit problematic.
At
So
10:30, I
one
can
thing-
start and
No, we'll do one thing. At 2, he may take, say, half an hour. Say,
Lordship.
Sir.
and then we can continue up to 4. Rest Monday. That will do.
no, at one go, Lordship, I would like to finish it off.
Then to Monday it will be
Tuesday.
list is already there from Monday. So
Tuesday, Lordship.
no. What I'm saying, next week I have some issue that I have to go Arunachal for my upline bench. So from there, it may be problematic. So because we have
Because
to
I will
ask
not
the
be able
order
to
also.
finish today. That's why
No. Pardon?
I will not be able to finish
No,
today.
it's okay. I can understand. So
Lord.
we requested the registry to list less numbers of matters today.
Or if
So we'll
Lordship,
do one thing. Say up to 4, you may continue.
or Lordship,
Otherwise-
if Lordship goes to Arunachal also, I can do VC because Monday is a VC day.
No, it will be a problem. So, no, next Monday we are not going. We have some things. The Monday list is already there. কিবা এটা কৰি দিব নহ'লে, উপায়তো নাই, কি কওঁ। ওচৰ নহয়, 10:30
মোক কৈ দিবা কৈ দিবা
পিছমিলত মোক কৰিব পাৰে।
আপুনি এটা information দিয়ে।
এতিয়া তন্ময় মহন্ত নিচিনা কেতিয়াবা দিছে নে
I see. Okay, then you finish your part.
Yeah, my-
We'll do something. You will start Monday at 10:30.
Lordship. Because he will take, now he is saying that I will need another 1 hour.
No. I have to show the law now. I'll show law. Only nothing more.
Yes.
Facts, I have already stated because he will take 3-4 hours. I don't know what he'll show.
The facts I will show.
So your case 28 as well as the 27 most probably they are both were fixed for order delivery of order. It was heard by another court in bench.
May I present the facts, Lordship?
No, we are not listening the case record. It was heard by our coordinate bench. It was listed for delivery of order. So we are going to list these two matters before the coordinate bench, before whom the order, you have placed your argument. We are not going to hear the matter.
My lord, may I place a humble submission, Lordship?
No, we are not going to hear any submission. We are simply saying that matter was heard by the coordinate bench. It was fixed for delivery of order. So we are going to fix the matter before the said coordinate bench. It was wrongly listed before this court, that much only. We are not going to hear the case because it has already been heard by our coordinate bench. So it will be listed before the coordinate bench for delivery of order, that much. We are not going to hear anything now. What you have submitted before the coordinate bench, it's already recorded and the matter was fixed for delivery of order only. Order will be delivered at most probably conveniently, but it was wrongly listed before this court. It ought to have been listed before the coordinate bench, but it is wrongly listed before this court. That was the other counsel is also submitting because it is for delivery of order. Case 28, okay, as well as 27 most probably they have both been fixed for order. 27 and 28. You are Mr.
M. Bosumotor.
M. Bosumotor. 27.
Lordship, may I place a humble submission? Lordship, item 27 was heard, but item 20 was not at all heard, Lordship.
But it will be heard by the same coordinate bench. If it is
Lordship,
not
there
heard.
is one more angle to it. There is an IA 195 which has been wrongly listed today, Lordship.
No, whatever, if it is supposed not heard, even not heard because these are two connected matters,
Lordship.
it will be heard by the same coordinate bench,
Maybe.
even if it is not heard.
Lordship.
You will get an opportunity of hearing also,
Lordship.
if it is not
Lordship.
heard. Mr. M. Basumatrai, learned counsel for the petition in criminal petition number 558 of 2024, and also heard Mr. M.K. Agarwal, the the petitioner in person for for criminal petition number 558 of 2024, along with IA criminal 159 of 2020. It is submitted by Mr. Basumatrai that the case was already heard by the coordinate bench of Justice Justice R. Mujumdar, and the date was fixed only for delivery of order. However, it is submitted by Mr. Agarwal, the petitioner in person, in appearing in criminal petition number 558 of 2024, that this petition was not heard, though the other matter was heard by the coordinate bench. In view of this, let both the matters. In view of this, it is seen that these two matters are wrongly listed before this court, and according to the registry, is hereby directed to list these two matters before the proper learned coordinate bench, before the proper appropriate list accordingly. Do you want any date?
Lordship, Monday.
Date we cannot fix because it is for delivery of order.
Lordship.
So make a mention. It will be listed next week. You make a mention before the bench. Registry. It will be listed accordingly.
Lordship.
Okay. So list it. Okay.
Bless. My lord, so the facts of the concern, and I have already, my lord, now the question before your lordship is that whether at this stage, whether my custodial detention is necessary or not in view of this. Now, whether I'm entitled to for bail or not. Now, why I put the behind the bars? Number one, your lordship has to see that whether after, if I enlarge on a bail, Lord, can I do tampering with the evidence? Can I do a hampering, or because there is no investigation, such it has been filed, and I'm behind the bar for 8 months for nothing doing, my lord. Now that is why, my lord, now I want to place some now for the law regarding your lordship may first, my lord, take 2021 that did 2 SCC page 427. That is a case of Arnab Manoranjan Goswami, my lord, where he has been put behind the bars. I'll not trouble your lordship by citing all these paras, my lord. Only the para what I want to brought before your lordship is the paragraph 66, that is J. Paragraph 66 of J. 67, paragraph 67. Paragraph 67, that is human liberty and role of courts. Human liberty is a precious constitutional value which is undoubtedly subject to the regulation by validity enacted legislations. As such, the citizen is subject to the edicts of a criminal law and a procedure. Section 482 recognizes the inherent power of the High Court to make such order are necessary to give effect of the provision of the CRPC or prevent abuse process of any court or otherwise secure the end of justice. Decision of the courts requires the High Court in exercise jurisdiction entrusted them so and so to act circumspections. In emphasizing that the High Court must exercise this power with sense and restraints, the decision of the court are founded on the basic principle that due enforcement of the criminal law should not be obstructed by the accused taking recourse to artifice and strategies. But the public interest ensuring the due investigation of the crime is protected by ensuring that the inherent power of the high courts in exercise with so and so, so and so, so and so. My lord, I'll just not, then, my lord, paragraph 69 and 70, my lord. Because I'll not read all these things. And it would be apposite to extract the observation made, albeit in a dissenting opinion by one of us, so and so, in a decision of a three-bench judge, Romila Thapur versus Union of India. The basic entitlement of every citizen who faced with the allegation of the criminal wrongdoing is that the investigating process should be fair. This should be integral component and the guaranteeing against the arbitrariness under the Article 14 and the right of life and personal liberty under the Article 21. If the court were not stand by the principle which we have formulated, we may witness the soulful requiem to liberty. The decision was a dissent in the face of the case. The view of the leading majority judgment is undoubtedly the view of the court, which bind us. However, the principle quoted above is in line with the precedents of the court. More than 4 decades ago, in a celebrated judgment in a state, Rajasthan versus Balachan, Krishnayar pithily reminded us the basic rule of our criminal justice system is bail, not jail. The high courts and the court in the district judiciary of India must enforce these principles in practice and not forego that duty. Leavening this court to intervene at all times, we must in particularly also emphasize the role of the district judiciary, which provides the first point of interference to the citizens. Our district judiciary is strongly referred as a subordinate judiciary. It may be subordinate judiciary, but it is not subordinate in terms of the importance in the life of the citizens or in terms of the duty of the render justice to them. So now, my lord, I skip all these things. The principle which has been laid in so far this is concerned, my lord, what is visit we should exercise regarding so far the bail is concerned, my lord. Jail is an exception, my lord. Bail is the rules, my lord. What, my lord, recently, my lord, the Supreme Court also, I will come to that also, my lord. Next, I will just it is Sheikh Javed Iqbal, my lord. My lord, that is authored by, Javed Iqbal is authored by Honorable Justice Ujjwal Bhia, my lord. My lord, taking in a reference of the case of K. Najib, the three-bench judge, by authored by President Chief Justice, my lord. Now, what it says, I'll just, one line, my lord, I'll just, citation is, my lord, 2024, my lord, 8 SCC, SCC 293. These are the case having a very serious allegations. They have been arrested under the Unlawful Prevention Activities Act. Yes. These are very, very important. That whether, my lord. So that is why by my lord, Najib case has been brought into, my lord, and what it says, your lordship will kindly sit. No, 42. I'll not, 32 is regarding condition, my lord. 38 is a condition, but I'll not go for the condition, whatever is written. I just come to only one para, that is 42. I'll not go 38, 42. My lord, what it says, this court has time and again emphasized the right to life and personal liberty, enriched under the Article 21 of the Constitution of India, overreaching. Sacrosanct, a constitutional court cannot be restrained from granting bail to an accused of an account of restrictive statutory provision in a penal statute if it finds that the right of the accused under trial under Article 21 of the Constitution of India has been infringed. In that event, such statutory restriction would not come in the way. Even in case of interpretation of a penal statute, howsoever stringent it may be, a constitutional court has to lean in favor of the constitutionalism and the rule of law, which liberty is an intrinsic part. In the given facts and particular cases, a constitutional court may decline grant bail, but it would be very wrong to say that under particular statute bail cannot be granted. It would run counter to very grain of the constitutional jurisdiction in any view of the matter. K.A. Nazib, that I will come to the K.A. Nazib case also, being rendered by the three-bench judge and is bending on the bench of the two-bench judge. So, my lord, here also, my lord, this it is under the unlawful prevention of the bail has been granted, citing the K.S. Nazib cases, my lord. Now, if your lordship kindly see regarding K. Nazib case, my lord, that is reported in 2021, 3 SCC, my lord, page 713, my lord. 2021, 3 SCC, page 713, and just one paragraph, that is paragraph 15, my lord. 15. 15, 1-5. That is 1-5. And just one paragraph I'll read, my lord. This court has clarified in a numerous judgment, because it's a three-bench judge, my lord. The liberty granted by Part 3 of the Constitution would cover within protective ambit not only due procedure and fairness, but also access to the justice and speedy trial. In Supreme Court Legal Aid Committee representing under trial prisons versus Union of India, it is held that under trials cannot be indefinitely be detained pending trial. Ideally, no person ought to suffer adverse consequences of this act unless the same is established before the neutral arbiter. However, owing the practicalities of the real life, where to secure an effective trial and is ameliorate the risks of the society in a case, potential criminal is left at large pending trial. The courts are tasked deciding whether an individual ought to have been released pending trial or not. Once it is obvious that timely trial would not be possible and accused has suffered incarcerations for a significant period of time, the courts would be ordinarily be obligated to enlarge the bail on board. Now, here, my lord, I pause for a moment this paragraph. So for this, now I am an UTP now. Here, your lordship will find that whether trial, so far the charge has not been framed as on now. And there are as many as, my lord, there are 394 listed witnesses. And documents are, seizure documents are also there. There are seizure documents today of 372. Material objects are there. Assuming, my lord, a 365 days. Out of 365, 52 are Sundays, 24 are Saturdays, second Saturday and fourth Saturdays. It will come around about 50 days of working days. That too, it not be possible for whatever day by day if it trial goes, it will take minimum 2 hours to 3 years or 4 years old. Thereafter also they have a court vacation job. 394 listed witness. Seizure documents 372. Material objects 29. So now, my lord, your lordship will find the paragraph where my lord, I quoted that if I see, so for 8 months, no charge frame as of now. Now I'll come, my lord, the next cases, my lord. So, 20.1. My lord, this case is a very important that this has been pronounced on the last Monday in the case of Soed Iftikhar Enderby. It was not reported as well yet.
Yes, Justice Ujjwal.
Yes, my lord, authored by Ujjwal Bhaiya. It is beautifully written. So for the public liberty is concerned, my lord, personal liberty is concerned, my lord. It is beautifully. I'll come to this paragraph, my lord. 102 pages judgments, my lord. Your lordship will find everything has been clear. What has happened, my lord? This is against the national investigating agencies. That Andrabi had been booked under NSA, my lord. He was put behind the bar. Then he challenges before the High Court of J&K. But when the order was being reserved, the central government, he has been shifted to the Lucknow jail, and central government has withdrawn the case. NSA has been lifted. Thereafter, after lifting, my lord, the police has started filing a case, a registered case. In that case, so he has been, there's an investigation and the charge sheet has been filed, alleging that he possesses a huge case of 1.8 crores and also drugs and having a connection with LET, Lashkar-e-Toiba. That's why he has been, very serious allegations has been made against him. Now, while granting the bail, my lord, I just quote this paragraph. The lordship will kindly see the paragraph. I'll come first paragraph. (20.1). It is page 46. My lord, on the last listen, there's 20, then 20.1. Your lordship got, my lord. Page 46.
Yes.
Page 46. On the bottom, your lordship will find this part. Now, your lordship will find, while considering the bail prayer of the appellant in the case, the court observed that while liberty of a citizen is undoubtedly important, but that has been balanced with security of the community. A balance is required to be maintained between the personal liberty of the accused and the investigation right of the agency. The court emphasized that the such balance must result in minimum interference with the personal liberty, my lord, of the accused and the right of the agency to the investigating the case. Now, next, observing that the stage of granting bail, a detailed examination, my lord, this is very important, my lord, detailed examination of evidence and elaborated documentation and merit of the case is not warranted, my lord. Why I have said that I do not have all this 103, my lord, murder, my lord, and conspiracy. That is why I, my lord, what we show that it is not required, that whether my custodial detention is, that is a minimum practice and procedure, whether my custodial detention at this stage is required or not. Prosecution has to give a reply to that. Why my custodial detention is necessary, my lord. Merely because the sentiment, your lordship, then it goes one step ahead, my lord. The court held that right to bail is not to be denied because of the sentiment of the community, my lord. Exactly, my lord, this case fitted in this case only. Yes, we also feel bad of dying of a person, of a singer like Zubin Garg, my lord. But we have to within the four corners of the law. We cannot go out, my lord. We do not go by the emotions, my lord. We have to go by the law, my lord. Because of the sentiment of the community against the accused, in the fact of the case, it is found that the NIA has submitted a supplementary search sheet which was variance with the search sheet filed by the anti-terrorist squads, my lord. And that the trial is likely to take a long time with the appellant in the prisons for about 8 years. My lord, why I have said 8 years? Because he was under NSA first. So thereafter it has been withdrawn, and after the withdrawal, the High Court also passed an orders that setting aside his detention, my lord. Now, next is the case, Najib case has been referred, which I referred earlier, my lord. I just skip one. 21.1, my lord. This court referred to his provision decisions where it has been clarified that the liberty granted by Part 3 of the Constitution would cover within its protective ambit not only due procedure and fairness, but also access to justice and a speedy trial, my lord. To Article 21, I am entitled for that. Once it is obvious that the timely trial would not be possible and the accused is suffered incorrections, for a significant period of time, the court would ordinarily be obliged to enlarge them on bail. Now, again, last 23.2, madam. 23.2. As regard right of an accused. Oh, I'm sorry. What did? The paragraph 23.2, as regard right of an accused to a speedy trial, the bench understood that such need being an essential facet of Article 21 of the Constitution of India. If the alleged offense is a serious one, it is all more necessary for the prosecution to ensure that the trial is concluded expediently. Bail cannot be denied only on the ground that the charges are very serious, though there is no end of sight of the trial to conclude it. The best quoted like so and so, so and so. Now, next minute, paragraph 24, Miller. We may also take note of the case of Arvind Nam as a director of enforcement, in which the case of the appellant was granted bail, albeit in a case of economic offense under Prevention of Money Laundering Act 2002. However, Section 45 of the Prevention of Money Laundering Act 2000 lays down stringent and restrictive conditions for grant of bail. In that case, the appellant was arrested on so and so. The court noted that cognizance of the prosecution complaint was yet to be taken. Total 208, my lord, prosecution witnesses are to be cited. We have 394. It was in the context, here also, no cognizance has been taken so far the pre-MLA is concerned, my lord. And in this context, the court reiterated and declaration of the law made the Zabed Nakib say that if the state or prosecuting agency, including the court concerned, has no wherewithal to provide the protect the fundamental right of an accused to have a speedy trial and enriched under the Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that the crime committed is serious. That was for the prosecutions, Lord. It has for the prosecution, it should not be object for the bail. Article 21 of the Constitution applies irrespective of natures of the crime. This court emphasizes the right of the speedy trial is not eclipsed by the nature of offense. Prologue encourages of an under trial without commencement of a reasonable progress of trial cannot be countenanced, as he has effect of converting pre-trial detention into the punishment. Is the effect of converting pre-trial detention into punishment. In the fact of the case, this court directed the appellant to be released bail during the pendency of trial. So that's paragraph what it says. They are only 208. Charge has not been, even though there's a it's a question, it's a matter where the case of a money laundering is an economic offense. Well, at 27.2, now what? There's a Purvinder's case, where their bail has been rejected, then what Lanet Court has observed, in our view, the decision of Gurvinder, inasmuch as it refused to be bound by the Najib, is difficult to be followed by us as a matter of precedence. It is plain that a judgment rendered by a bench lesser strength is bound by the law declared by a bench of a greater strength. Judicial discipline mandates that the such binding precedent must either be followed or, in case doubt, be referred to the larger bench. A smaller bench cannot dilute, circumvent, or disagree the ratio of the larger bench. What it has been observed. That is, the bail has been rejected, and it said that No, when there is a three-bench judge, my lord, we have to follow that. Twenty-seven. It was the court call. 35 or 38. My lord, para 35. 35. Here everything is there. Page 76. The often invoked phrase, bail is the rule and jail is the exceptions, is not merely an empty statutory slogan. Following from the CRPC, as Gurvinder has stated, it is a constitutional principle flowing from Article 21 and 22 of the Constitution and the presumption of innocence, which is cornerstone of any civilized society governed by the rule of law. Statute may undoubtedly calibrate the manner in which that principle is applied, particularly in a case involving national security or terrorist offense for which UP Act is meant. But those cannot altogether invert the constitutional relationship between the liberty and detention. The statutory embargo of Section 43D5 must remain a circumscribed restriction that operates subject to guarantee under Article 21 and 22 of the Constitution. Therefore, we have no manner of doubt in stating that under the UP Act, here is the case which has been said under the unlawful act. So far, we are concerned that is what is the allegation of murder, That is why it said that bail is the rule and jail is the exception. Why it has been said? On the court, appropriate case, bail can be denied having regard to the facts and particular cases. Then, my lord, 38, my lord. Thus, it's clear beyond doubt that the preference for bail or often invoked principle bail is the rule and a jail is an external flow from the constitutional primacy of personal liberty under Article 21 and therefore cannot be displaced by legislation. So these are the paragraphs which I brought before Lordship for consideration of my bail. These are the cases where serious allegations, that is under the Terrorist Act. And my lord, we say that even if, though it's very stringent law, my lord, this bail is a rule and the jail is an exception, that has to be also can be applied. So these are the things, my lord, which, my lord, I referred to this judgment, my lord. Elaborately stated, I have not gone and I have not cited everything, my lord. Just short, to cut short, I just mentioned the paragraph only. Relevant paragraph. No, relevant paragraph. Now, here, your lordship will find number one. So far, my detention is concerned, my lord. The lordship has to see now what it is saying. We don't have to evaluate evidence, all these things. Now, whether my custodial residence is necessary at this stage or not, and whether I am entitled for bail or not. Already, my lord, all witnesses are examined. All document has been seized. My passport is there. My so-and-so. So, if I have been released, can I, my lord, think? Be away from the country? My humble said, no, my lord, I cannot. That is number one. Secondly, my lord. Secondly, my lord, I have can I anyway, my lord, temper or hamper with the evidences or witnesses, my lord? That cannot, my lord. It cannot, because it is with the this thing, how can I, my lord? I'm not so influenced, my lord, to go and tamper with the evidence, my lord. All records are in the courts. Hardly, my lord, my personal liberty, my lord. Lordship will kindly see what my fault. I organized not his festival. My fault is I organized. And the person, he has gone by and an accident happened and he died. The person has died. And we have been implicated for no fault of mine. So now my entire family, my lord, are in a state. All the bank accounts has been also been nothing. I cannot do anything, my lord. I have applied, my lord, that is also rejected. Please. Huh? No. See, that's a decrease of the account, but I was allowed because I asked to give me your the credit cards, the others, what are the related the bank documents. That is also rejected because you say you are the wife, I cannot give you. So that is the ground for rejection. So we are having going through a difficulties time, my lord. My entire family, my lord, at stake. Not only me, my entire family has been in stake. My responsibility before that, why I have come before this honorable court? Because we come before the temple of justice, my lord. We wanted justice to be given to us. My personal liberty should not be preached, my lord. That is my humble submission before this honorable court. And I conclude, my lord, by saying this. I will not take.
Your citation.
My lord, I cited these are the 4 cases I've cited. I will not cite more. These where the principle has been laid down, so far the bail is concerned. Subject to, I'll get a right of reply. I'll not go for the what my learned Advocate General placed me.
So on Monday.
Assisted by. Assisted by Mr. Ketan. Assisted by Mr. PM February, we reflect your name as a, you also here, PM.
Yes.
Special permit.
They have a batteries of lawyers, brother. You are and but one against all odds.
More heavier than us.
And Mr. Medhi was also there for informant side, I think he's
Everyone.
WR meeting for the the matter at the district matter on Monday, 25 at 10. Sorry, 10. We're listing it and exactly on 10:30. There may be some mention matter, 4-5 minutes will 5-10 minutes will be there.
Lord.
And thereafter we'll start it.
Lordship. Lordship, should we keep the case diary or it can be submitted?
Case diary are with
It is in a trunk or what?
more or less.
Submit on that day only.
Lordship.
Sure.
Because we have the pen drive or you will keep there only by sleep.
Because it was court order, so we have. taken
Yes,
your-
okay.
Pen drive to ase to.
Highly obliged.
Pen drive is with us.
Mass obligation.
Okay, with the- Oh, it is- it's on the- it's on- by sleep. Remain. Yeah.
Justice Lordship, kindly timing the matter. My senior is another
Item number
16 and 17.
16 and 17 both together, Lord.
to get Oh, same council is there. We'll try, but we're going to rise by 4:30. So if time permits, then only we'll hear. Okay, otherwise, what is the position? Have you received the case diary?
Yes, I have received.
Received. Okay, we'll see to it. It may not reach also. We are rising a bit early. Yes, Nambi. What is the position of 18?
18, 19, Lordship CD not available.
18 is which 19?
19 is also there, Lordship.
I mean 18
Same.
and 19 are of same.
Same FIR is same, Lord.
CD not received.
CD not received, Lord.
Are they or injury?
Earlier, Lordship, interim was in, huh?
It was there.
They are not on interim, Lord.
Oh no. Interim was there in item number.
We
In
don't-
both the matters,
it is not
interims are there.
It is not written,
Interim was there.
Lordship.
Interim is there.
Okay, Lordship.
So you have not received the case.
Not received.
18 or 19. 18, 19, city not received, should remain. Yes, when it can be.
Then data dedicate your ball. Lordship.
16th of June, interim be continued till next year.
Granted also, we have received the case diary, petition item in time, but the statement of the petition is not in the case diary. But he has appeared, the order copy is here, of the statement is not here in the case diary.
But copy of order is there.
Yes.
Then they have appeared. I think.
Appeared, but statement is not here.
As per your instruction, what is the instruction?
He has appeared, my lord.
Appeared.
Appeared, my lord.
He's on interim, let's see, we have send it back for a statement.
Partners to A.P. Gupta, the Lalip counsel for the petition. And also for Mr. D.P. Goswami, the Lalip counsel for the petition. It is submitted by Mr. Goswami that the CD received, but the statement of the petitioner is not available. So however, the order of interim is available in the case diary. In that copy, Mr. Goswami submitted that by his instruction, the petitioner has already appeared before the IF and his statement is. So in view of this, let the CDB return written calling for an updated one with a direction to the IF to furnish the case diary along with the statement of the petitioner, if already recorded. Further, the petitioner is directed to appear before the IO within 7 days from the date of order, if the statement is not yet recorded, not yet. Yes, when it can be
17-6.
17-6, so and so, interim be continued till next day.
Obliged.
Yes, what is the position of 22?
22, Lordship, we have received the case diary. But the case diary is up to date on 17 to 26. Going to the case is a case of 103 section under section 103, Lordship. 103, no? 103 plus 1.
17-2.
17-2. At
So
this
you
case,
need the updated one or what?
update is
Whether
required.
the PM report, etc. or
PM
also
report-
available.
PM report is here, but going to the case diary, nothing can be found at this stage of investigation. Going to the case diary, because from as far as statement of the witness, somebody killed a person. Who was the prime suspicion is this petitioner.
That
So
further
for
updated.
a
you need.
updated investigation is required.
Yes, you are Mr.
Islam.
Heard Mr. I. Islam, the learned counsel for the petition. Also heard Mr. D.P. Goswami, the learned additional PDF object response. It is submitted by Mr. Goswami that the CD is not updated and investigation seems to be under progress. He further submitted that the CD, the last entry in the CD was in the month of February. And accordingly, he submitted the updated case diary. In view of this, CDB returned back calling for an updated one. Yes, they are not on interim.
Not any time. 10th of June, Lordship. We have to send back.
Pardon?
10th of June.
10th.
24.
May please, Your Lordship.
Yes, what is 24?
This is anticipatory bail application. Your Lordship was
Now it's
pleased to.
okay, now you have received the case diary.
Yes, that is the receipt. Your Lordship was pleased to grant interim protection to the petitioner number 1, my lord. Petitioner number 1, after being granted interim protection, has appeared. Perhaps her statement is also recorded. Her statement is recorded, Lordship. Your Lordship will kindly come to the FIR, my lord, which Your Lordship will find at page number 16, my lord.
Yes.
May I read the FIR, my lord?
Yes.
Respected Madam, sir, my name is so-and-so, a resident of so-and-so place. I am writing this application to formally lodge a complaint and seek urgent help regarding continuous harassment, threats and serious safety concerns caused by Mr. Parashpratim Sonwal. This is the petitioner number 2, madam. The harassment began in 2022, shortly after my mother passed away. At that time, I was only 16 years old and an orphan, which made me extremely vulnerable. Mr. Parashpratim Sonwal, who is my elder sister Snigdha Besbarua's boyfriend, started sending me inappropriate messages using my sister's WhatsApp account. He proposed that I engage in physical relations with him. Due to my young age and difficult situation at that time, I was unable to take any action. Now, this is in 2022, my lord. After almost 2 years, on April 24th of August 2025, he again contacted me through my sister and repeated the same inappropriate proposal. When I protested against his behavior, he started threatening me. Following this incident, the Demo police detained him. He apologized and gave a written statement promising that he would not contact or harass me again. However, after this incident, he continued to threaten my family members and friends, causing me severe mental harassment. He made threatening phone calls to my cousin, brother, and relatives who supported me during this situation. On 15th January 2026, he contacted my friend Priyanshu Shrutikar and threatened him for helping me. He also attempted to damage my reputation in front of him and even went to Priyanshu Shrutikar's house to intimidate him and stop him from supporting me. On February 26th or 24th February 2026, he again attacked my friend near Vineshwar Brahma Engineering College and openly stated his intention to harm me. On the same day, my friend filed an FIR against him in Kokrajhar. However, the Kokrajhar police delayed the process and did not respond properly. The FIR still has not been registered by Kokrajhar police. Additionally, we believe that he may have illegally accessed or manipulated my phone and collected private photos of my friend. Recently, he even posted some private photos of my friend Priyanshu Shrutikar. I am extremely worried that he may also possess my private photos and may misuse them. Because of the situation created by Mr. Parashpratim Sonwal, I was also forced to leave my house on 15 January 2026. Due to the actions of both him and my sister, I am going through severe mental stress. As an orphan, I already lack family support. And now even the few people who supported me are becoming afraid because of his threats. Due to all these incidents, I'm living in constant fear for my safety and reputation. I have recently filed another complaint against him at Dibrugarh police station, as I'm currently a student in Dibrugarh and cannot return to my hometown due to my safety concerns. So this is the allegation which has been leveled against Priyanku and the sister man. Now, as is apparent from the FIR, her parents are dead, she is an orphan. The petitioner and the informant sister, now they are disputing over the ancestral property matter. And this, after the parents died, the informant at that time was minor. Now she is around 20 years old. He was living with the sister. She was taking care of him. But thereafter, because of this person, my lord, which your lordship has found his name, my lord, Priyanku Shrutikar. This Priyanku Shrutikar happens to be the boyfriend of this informant, my lord. And the sister, as well as the petitioner number 2, my lord, they did not approve of Priyanku Shrutikar. And then the informant started demanding that her property share be given to her. And because of this dispute, now all of a sudden this FIR has come to be lodged against the informant, against the sister as well as her boyfriend. Now, she alleges that there has been messages and other sort of threatening calls made to her over the phone. The investigation is going on. If the police has been able to collect any materials to show, because as far as our instruction goes, my lord, these are absolutely false allegations. And even the offenses, my lord, 351, that's criminal intimidation, that happens to be bailable, my lord. Then 75(2) is there, my lord. 75(2) is, my lord, regarding demand or, among other things, a demand or request for sexual favors, that is non-bailable. That is the only provision which happens to be non-bailable. There's demand or request for sexual favors. But even that, my lord, the punishment is only 3 years, my lord. So the whatever materials the investigating agency has collected, my lord, to support the informant's allegation, my learned friend may address this honorable.
If I look into the FIR itself, Lordship, it seems that there is a harassment of, the harassment is there, Lordship. And section 75(2), that is the only non-bailable section, Lordship. And if I look into that, it is attractive. Because if I look into the FIR, there has been sexual flavor has been made, Lordship. It is in the FIR also. And one, I have also the flag mark, Lordship, the 183 statement. It is clearly shows that there is implications are there. And regarding this sister, and regarding the sister, she has stated that, Lordship, she apprehend that the private photo, I have flag mark, Lordship, her private photo from her gallery has been given to this person, that is the petition number 2, the boyfriend of the person, Lordship, to give the threatening part that she will viral this photo. And her sister, younger sister, stated that it is given by this, her elder sister, Lordship. It is there in the 183 statement, Lordship. It is in the 183 statement, Lordship. Her private photos has been given to this person, boyfriend, and he has given to the girl. And stated.
He is boyfriend or husband now?
No, boyfriend, Lordship. The boyfriend, the petitioner number 2 is the boyfriend of her elder sister, Lordship.
It's a boyfriend.
Boyfriend of the elder sister. And he is asking for sexual favor, Lordship, from this elder sister. Oh, sorry, Lordship, younger sister. It is there. Lordship, kindly go through the
Regarding
183.
the cooperation of the elder sister.
Otherwise, Lordship, her statements are there and materials are there in regard to 75(2), Lordship. And in regard to her sister, Lordship, elder sister, she has helped to get back the photo, Lordship.
So from what I've understood from my learned friend's submission, that is the content that's there in the FIR and in her 183 statement. So the statements the allegations which she has made in her FIR, there is no reason for her to go back on that statement. So she has reiterated the same statements in her 183. But whether the police has been able to collect any materials, see, informant is there, informant has gone to the police, she has lodged the FIR, whether the police has seized her mobile phone, whether the police has found any messages from us.
It is there, Lordship. It is in the WhatsApp messages are there. It has been there, and she has in the FIR also. It has been stated that the person has used the elder sister's phone. It is there in the FIR also.
No, it's okay. Now, what I'm saying, what Mr. Nawaz is saying, that obviously there is some allegations of even this sexual favor, demand of sexual favor is also there. Apart from some threatening part and to make some viral photos, and these private photos are there, that is there. And obviously, as you have submitted, I'll go by this. But in the 183 also, that supports the case. So apart from that, is there any case? Because one submission from the other side is that due to only there is some property dispute as she demanded the property. This kind of things came out, and subsequently the FIR was lodged by her at per advice or instigation, whatever, from her boyfriend, one Priyanshu or whatever. That is their submission. So in that regard, is there any or there is nothing?
I have not found, Lordship, in that regard.
Otherwise, this support of she made her submission in support of her FIR itself, it is okay.
Lordship.
Now, apart from that, are there any?
Kindly give me for a few minutes, Lordship. 1 minute.
Because what I am submitting
regarding that, Lordship.
Regarding that, submitted on that also is submitted. That due to some
other
property
materials are there.
demand for property by the victim, this kind of things have come out. Is there anything?
Statement and FIR are there. Allegations are there in FIR. Allegations are also there in statement, and that is understandable. If she, because there's a property dispute and she makes an allegation in the FIR, it is expected that she would also make the same statements same allegations in her statement. But her phone should have been seized by the police. Whether the police has found out any material, any message where I have demanded sexual favors from her, or whether she says that her own sister has given her photos to the boyfriend. Whether
No, but the allegation is that he used to use the mobile phone of her elder sister.
So
not from his mobile, whatever messages or whatever text or whatever photo, From that elder sister's mobile only he
Yes.
used.
So that would imply that the informant's private photos would be there in her elder sister's mobile phone also.
Yes.
And then from it, the husband or the boyfriend has taken it. Some material must be there that they have seized the phone, because except for her own allegations in her FIR and 183 statement, it seems there is nothing else there. These allegations will have to be supported by, yes, my lord. So only that part he can address, my lord. Otherwise, this section is punishable with 3 years of imprisonment.
There is a messages are there, lordship, but other in regard to that property regarding dispute, it is not there. However, the WhatsApp messages are there. WhatsApp messages are there, lordship. The conversation
Phone has
between them.
already been sent for any FSL and all, is there?
It has not been stated, lordship. But CDR has been taken, lordship.
We want to
Fix
take
it on
that,
Monday then, lordship.
go through
I will
it,
look into
because
that.
this is the main contention of
Not
the other
this.
side, that it was merely because of this allegation,
Property.
or under the instruction of her boyfriend only she lost the affair. So if the other things are there, if mobile has already been sent, the CD analysis is there, go by
Yes.
that, we'll see to it.
CDR analysis is not there, but they have taken the CDR.
The it has already been sent.
And it is not stated that it has been stated, sent to FSL.
Must be time legal, yeah, no problem.
I need some time, lordship, so it may be.
We are not fixing any cases on
Okay,
Monday.
lordship.
From
Lordship,
10:30
then time being,
onwards,
for time being,
entire day will be,
Lordship, then-
that matter will be heard.
lordship,
On
then.
26 of this, there are some reasons we are not
Yes,
speaking.
eta নাই.
And 27 there maybe, I don't know, but we may utilize some
Lordship, then time being, I will look into that, other matters may be taken, lordship.
time being, so what can I say? Yes, it can be, it can be.
Because other matters are there, lordship. Up to that.
Not
only.
many, not many. I'm going to rise.
I will go, I will complete, lordship.
নহলে কেতিয়া কৰিব পাৰিব? Next সপ্তাহত কি লাগে? কি হবে? At least we can, can you retain the case diary up to first of June?
Lordship,
Can it be retained?
lordship, we can.
Just can retain it,
Lordship,
because
lordship.
this week
Lordship,
there is a problem,
lordship,
some
lordship,
problem, I
lordship,
have
lordship.
some problem because of one
Lordship,
issue.
We will
So,
retain that. We will retain the
you
suit.
just retain it,
Lordship.
then okay, hard Mr. S. Nawaz denied it for the petition, also had Mr. Detention denied it, Muslim PFD about it. Senior receiver.
It is my
But,
concern.
Mr. Submitted it in
Interim
some
process.
in view of this, case matter on 1/6/2026, retain the case date till next date of listing. Interim granted to the accused petition number
Number one,
six,
madam.
two, na?
One.
Or one. One is hereby extended till the. Okay, then.
I'm deeply aware.
Yes, what is the position of 25?
Yes, Ms. 25 minutes
City receipt.
is the receipt, my lord.
Second time, my lord.
After that, earlier
Up to
rejection
this-
order is at page 45, my lord. He is accused number 1 in the FIR, my lord.
Yes,
Accused number 1 India.
Earlier rejection order is at page 45, my lord.
yes. Our new ground is paragraph 9 of page 8, my.
Paragraph 9.
Yes, page 8. In fact, he was not there, my lord. He's a government employee, grade 4 employee, my lord. And he is the person who normally advised in the village, my lord, grade 4 employee also much more than powerful, my lord. He used to advise them, my lord. His brothers are there, my lord. Land disputes. We have given title suit also, my lord. Next, earlier it was not given, my lord. So because of he gives some sort of advice to them, so they wanted to implicate him, my lord. So he has been particularly, his name is there. Now you also see whether, my lord, subsequent development, whether actually he was there.
Regarding
Our only case, my lord, he was not there. 800 meters away from that here, my lord.
And he came only after hearing he went cry and took his brother to the hospital. Kabir, huh?
Incident guidance.
An incident in the night, my lord. What was it?
Night.
2:30 a.m. my lord. Identity also, and your lordship will find in the fire so many persons are named, my lord. Total 10, no?
9.
9.
This petition is for Abdul
Yes.
Abdul
Jabbar.
Jabbar.
Abdul Jabbar, my lord.
He is accused number
Accused number
one,
one.
in the affair.
All the rest of my lord, all the accused got bail, my lord. All. Only my lord friend will see, my lord, will show your lordship whether he
Yes,
was
sir.
present and whether he actually, my lord, he has hit him or not. Our information that he was not there, my lord. Subsequently, he has gone.
I will point out, my lord.
Yes, confirm. Iman lang lagi. Huh? Iman ki lagi. Ayaw no to kasi. Cost case page 34. Also, my lord. Then registered sale deed is page 21. Title suit page 30. Cost case page 34, no? Information naam kita ase.
Their main contention is that he was taking his injured brother Khabir Ali
Kabir Ali.
to hospital. Is there any such kind of statement?
Yes. My lord, I would like to point out, my lord, there are statement of eyewitnesses and injured witnesses was also there. One Khabir Ali, who inflicted, my lord, the head injury to the victim Hassan Ali. He was granted bail, my lord, along with other persons who were also involved on their, my lord, 72 days only on the ground of length of the term, that is BA. And regarding the present Abdul Jabbar, my lord, I would just like to
You're
point out,
saying Khabir Ali first initially inflicted injury.
yes, my lord, I would like to point out, my lord.
Kabir Ali already got bail, man. Kabir Ali.
Khabir Ali after
Regular bail.
72 days.
Regular.
Will point out
He is my younger
some
brother.
vital portion of the witnesses, my lord, regarding Abdul Jabbar and my lord. কবিৰ আলিয়ে লাঠিৰে মোৰ হাতত আৰু ভৰিত কোবাই জখম কৰে আৰু ফাইজুলে মোৰ ককাই হাছেন আলীক প্ৰথমে আব্দুল জব্বৰে এটা প্ৰেজেণ্ট পেটিছনাৰ মাৰি মাটিত পেলাই দিয়ে লগে লগে কবিৰ আলীয়ে লোহা ৰড আৰু বাঁহৰ লাঠিৰে উপৰ্যুপৰি কোবাই হাছেন আলীক গুৰুতৰ জখম কৰে কবিৰ আলীৰ মাৰত মোৰ ককাই হাছেন my lord thereafter that is regarding again one that is regarding Abdul Jabbar, my lord. Last portion is Abdul Jabbare মাৰি মাটিত পেলাই দিয়াৰ লগে লগে কবিৰ আলীয়ে লোহাৰ regarding that মই গুৰুতৰ জখম কৰে কবিৰ আলীৰ মাৰত মোৰ ককাই হাছেন that portion and again one other portion, my lord. Abdul Jabbare বাঁহৰ টুকুৰাৰে that is regarding other হাতত ভৰি টুকুজুপুৰি কোবাই হাত ভৰি ভাঙি দি গুৰুতৰ জখম কৰে যাৰ ফলত মঙ্গলদৈ চিভিল হস্পিটেলত হাছান আলীৰ চিকিৎসাধীন অৱস্থাত মৃত্যু হয় কবিৰ আলীয়ে হাছান আলীক মূৰত লু ৰডেৰে মাৰে আৰু ৰিগাৰ্ডিং আব্দুল জব্বৰ দেয়াৰ আফটাৰ মেলত আব্দুল জব্বৰ বাঁহৰ টুকুৰাৰে হাত আৰু ভৰিত উপজুপুৰি কোবাই মানে দিছ ইজ আব্দুল জব্বৰ And regarding other witnesses also, my lord, eyewitnesses, my lord, injured witnesses implicated Abdul Jabbar, my lord. He against Khabir Ali that he inflicted on the head of the my lord Hassan Ali, and the initially first blow that my lord Abdul Jabbar মাটিত পেলাই দিয়ে তাৰ পাছত কবিৰ আলীয়ে মূৰত আঘাত কৰে তাৰ পাছত আব্দুল জব্বৰে উপৰ্যু পৰিমাণত ভৰিত হাতত বাঁহৰ লাঠিৰে মাৰি জাঠেৰে মাৰি মাইলত হাছান আলীক আঘাতপ্ৰাপ্ত কৰি কৰে this is the allegation against the statement of the witnesses so they are implicated.
The FIR, my lord, accused number 1 assaulted on the head, but that is, my lord.
So it's okay, assaulted on the head.
Yes,
It is
Khabir Ali, my lord, actually, he was also injured. He was in the cost case, my lord. The wife of the Khabir Ali filed the cost case, my lord. And Khabir Ali is the person who I have come and I have taken him to hospital, my lord. This is our case. Subsequently, he came, my lord. That is. So this belies the FIR point. Here, the SP says accused number 1.
So, my lord, that he is not present on the day of the on the place of occurrence, my lord, that is not at all my lord, believable story because from the statement, not only one, my lord, single, there are other witnesses also named Abdul Jabbar that he is the person, my lord, along with Khabir Ali, yes, specifically he, my lord, inflicted blow on the head of the my lord deceased, and thereafter, my lord, initially, my lord, Abdul Jabbar matit pelai diye, and thereafter, my lord, he, my lord, Khabir Ali, and thereafter again Abdul Jabbar, my lord, by way of my lord, বাঁহৰ লাঠিৰে মাৰি উপৰ্যু কৰি কোবাই হাছান আলীক গুৰুতৰ দৰ্শন regarding
Khabir Ali.
Is submitted by Mr. Learned Senior Counsel that earlier his bail application was rejected by this court. But at that time it was not referred before the court that it was not brought before the court and there was a civil dispute and battle suit is going on between the parties. And on the day of incident, the petitioner was about 800 meters away from the place of occurrence. And during the noise, he came there and went and found his brother Khabir Ali in injured and immediately took him to the police. Further, he submitted that petitioner is a serviceman and he is ready to extend his cooperation if he is granted with the pre-arrest. Next, Mr. Bordakur, the Learned Additional PP submitted that the earlier bail application was rejected by this court on perusal of the case diary. And on further perusal of the case diary, it also reveals that this petitioner also took active part in assaulting the deceased and the deceased. He first hit the person and with a bamboo and for which he fell down on the ground and thereafter the other accused, namely one Khabir Ali, assaulted a victim on his head for which he succumbed to his injuries. He further submitted that there are some other eyewitnesses that are also present who also saw the occurrence and submitted and stated that the present petitioner initially assaulted the deceased and thereafter the Khabir Ali inflicted head injury on the deceased. Accordingly, Mr. Bordakur submitted that there are insufficient intimating evidence against the present petitioner who take active part in assaulting the deceased and assaulting the deceased. Next, hearing the submission made by the proposal, seen that the earlier bail application of the present petitioner was rejected, considering the matters however, on the petitioner initially hit the deceased, and thereafter a vital blow was given by the other accused, namely order from the from the case diary, it reveals that there is sufficient progress in the investigation of this case. And considering all these aspects of the case, as well as the civil disputed parties, this court is of opinion that one chance will be given to the present petitioner to appear before the IO and cooperate in the investigation of this case. But interim, there is. Okay, we'll providing some interim protection to you so that you can appear and cooperate. Next day, 76 can?
Yes.
Next day, 7.
Obliged.
On my lord.
Publish.
7-6.
7-6, man.
17-6.
17-6. Obliged.
26.
May I please the Lord?
Yes, were any days cases registered?
Yes.
One GD entry was earlier. there.
GDNT was there, my lord.
One GD entry
And without-
1228 of the 2000.
Without registering
Submit.
case, my lord,
Pardon?
the police, without registering case, my lord, the police disturbed the petitioner. He was asked to appear without any notice. And your lordship protected him, my lord, on 11/5.
Yes, yes. Were any report received?
Report is received, Lordship. No cases registered till now.
And
No case has been raised.
Yes, I have given you the report.
And yesterday, my lord, although your lordship protected, my lord, yesterday, my lord, police taken him to the police station and he was kept in police station for 2 hours. And
You,
So-
but you are not arrested.
no,
That is no course of action. Interrogation
Lord.
will be required.
Lord.
So,
Only thing is that the last time that the inquiry officer has called upon the alleged person to cooperate and explore an amicable settlement between the parties. However, the alleged person has not cooperated with the inquiry so far. No harassment has been caused to the alleged person. That's the report.
settlement, my lord,
so it is still, inquiry is still under process. Inquiry.
That the detailed report is submitted for your kind. No, so the FIR has not been registered in the matter so far and the preliminary inquiry is presently underway.
It's undergoing.
Lord.
Okay, then we may extend this
Okay.
because preliminary inquiry is still undergoing.
Yes, Lord.
Heard Mr. R. Ali Dilani for the petitioner and also heard Mr. P.P. Kusam Dilani. So, report received from the which police station? This is Basista. Basista police station. Wherein it is reported that the preliminary inquiry is still going on and the still going on. However, the present petitioner is not extending his cooperation in the inquiry. In view of this, let the interim protection granted to the present petitioner be extended till next date of listing. As the matter is still going under inquiry, is the matter is still undergoing inquiry, the petitioner is hereby asked to extend his full cooperation in the inquiry, which is still conducting by the Basista police station under GDE entry number. GD entry number 1228 of the list the matter accordingly 12th of June. 12th of June. Now see, you're against you. One allegation is that you are not cooperating.
No, this is
Just
my lord,
try
not
to
correct, my lord,
cooperate.
because he went twice, my lord.
But you are not cooperating. In that case, your case
Lord.
may be registered against you on that day.
Lord.
In that event, we may
Lord.
vacate your interim also.
So the report is part of the record.
Yes, report be.
Right.
Time. Yes, it will be on. Sixteen, 17.
Lord, interim will continue, well.
Yes, interim.
Obliged.
16.
16 and 15.
A to T. Yes, 16-7.
Call for up-to-date case diary.
Okay, that is received, Lordship.
CD receipt. No?
CD receipt. Here, Lordship, in the enquiry report is also there. And the victim statement is there, video statement is also there. If I look into the here is the case, Lordship. This is a case in which misappropriation of fund of our scheme, Lordship. The house that has been given to the by government. And in the case, what is there?
Detailed observation was made. Naval court order has clearly mentioned on 20.
Well, look into the
2025.
If I look into the FIR, Lordship, there are two persons are there. One Hemanta Hazarika, that is the Gau Panchayat Lordship Secretary. He is the petition number 1. And another is Lordship, that is Ayub. Another is Lordship Ayub.
Abu Said.
Only one petitioner. That Hazarika, Lordship, Hemanta Hazarika, he is the secretary.
No, another petitioner is Abu Said.
Abu Said. And he is the Lordship.
Hemanta Hazarika was the president.
Lordship. He is the secretary.
Secretary of the in-charge secretary of Anchalik Gau Panchayat.
And the other person, Abu Said, is the Gau Panchayat coordinator, Lordship. In this case, one inquiry report is there, and it very clearly stated the things, what had happened, Lordship. There are 4 persons, beneficiaries, that is Jamila Khatun, Solman Jan, Ramika Khatun, and Sorhab Ali. These are the persons, these are the beneficiaries, Lordship. And what this person has made, the names are the same, and they are actual beneficiary also. But the money that has been transferred to another account, Lordship. These persons are Khairun Nesa, Hasina Begum, Mumtaz Begum, and Jahed Ali. Transferred to another account. So,
Money transferred to not their
beneficiary are the correct one, but they have not received the money. They transferred to, when the money is given, the account, bank account details has been given of different person. This is the case, how they have misappropriated the money, Lordship. And in this case, the victim statements are there. They have also stated that they are the actual beneficiaries, but they have not received the money. And they have stated that Hemanta Hazarika and this Abu Said has misused this money. And for the process, how it has been done, it is in the present serving, not the then serving, but the present serving video statement is there. He described the process. First, government given the list to the CEO, then CEO given it to the BDO, and BDO give it to this person's Lordship. The present is the secretary and this person, Lordship. These 2 persons. And they have made the entire verification is done by them. He has stated in his statement. The entire verification is done by them, and the registration is also done by them. So it is a clear cut, they have misused the money, and one of the person's statement is also there. That is one Ramsia Khatun, Lordship. His son has stated that this person, Hazarika, has helped him to get the money. This one of the
He is not the beneficiary.
He is not the actual beneficiary. He is the fake beneficiary, Lordship, in whose account this thing has been given, money has been transferred. He has stated that this person helped him. So prima facie materials are there, Lordship. These are the facts, Lordship. And their statements are also there. If Lordship want to look into the CD, Lordship may can. They tagged also wrong house, tagged another house, Lordship, to do the whole thing, Lordship. The completion of the house, geotagging is there, Lordship. They tagged another house. And detailed inquiry report is also there. It is against him.
Yes, what is your submission?
In these cases on Lordship, one observation has already made out, that is 23/2026, wherein directed the investigation officer to make once again and submit uploaded case diary in regards to the specific financial year in which year the irregularity has been done. Only because of that, your Lordship, that in the said FIR itself lodged by the block development officer, who is one of the responsible officer of the said block, Lordship, under Gau Panchayat, your Lordship. The petitioner here is one of the in-charge Gau Panchayat secretary. Actually, his appointment was the tax collector, only casual employee and master or worker. He discharging his duties as an in-charge secretary. But in these cases, Lordship, there is no specific allegation in which year there is a irregularity has been done. Event of that, the departmental inquiry has been conducted only upon whenever the
Mr. Heri, question is that you have submitted things, it's okay. But on the by this by order dated, one detailed order was passed on 20/03/2026. Because there has to be some assessment on which financial year these things have happened.
It is there, Lordship.
It is there.
Lordship,
Now we need a report. In fact, report is also there.
it is there, Lordship.
Because we have seen that in view of above, the
Lordship, may
court is
first look
opinion
into
that
that.
IU should be detailed inquiry report in regard to whether the providing Union House 21/22 any misrepresentation. It was there.
It is there, Lordship. Lordship may look into
Inquiry report is
Let's
there.
see,
Okay.
it is there.
Inquiry report is already there. It is
Inquiry report, Lordship. 21/22. How it is misappropriated, it is everything.
no. We peruse these things.
Lordship.
If you go by the order, the detailed order was passed on 20/03/2026. It shows that there were some lists, 2021, it was registered, and it again, it was registration, so and so. These are already discussed in the order. So finding that the financial year was not described at all, under which financial year that misappropriation took place, because he took the plea that prior to his things, it had happened, so he is not related. This is his submission. So now, accordingly, we directed, in view of above, this court is of opinion that the IU should do a detailed inquiry in regard to whether the providing of the PMGY house scheme for the year 2021-22, any representation of fund or irregularity has been committed by the accused petitioner in those periods, including his tenure as in charge of Gauh Panchayat. That means 21-22, and thereafter he took his charge as a in charge Panchayat with effect from 26/3/2025. So in that regard, we asked the IU to make a detailed report. Is there any? This report I have already paid. It was there in the earlier order. I have mentioned about that also. But we need a detailed report. The ground of bail objection is there.
But I think Lordship report is not there. Then I have to communicate again, Lordship.
Just you do one thing. You go through the order passed by me, by this court, sorry. That was in order passed on 20/03. That was after perusal of the case diary. Because there has to be some specific period. Otherwise, the list you have annexed or the inquiry report, that is the 21/22 is already there.
Is there.
So That way it creates some problem when deciding the order. So I asked the.
Lordship, I will look.
This time you do one thing, let the order of 20 be accompanied with your notice to the IO. It will help the IO also, because detail has been described here.
But I will give it the Lordship order to the IO Lordship.
That will be.
Lordship, earlier several occasions, Lordship, chance was given to the Government Council, Lordship, to communicate and submit the up-to-date case diary, and repeatedly failing, and matter has been changed pending 25 of December. So today may can we dispose of this case with a certain direction. In the event, it is liberty to the government. He is the petitioner, both are the government employee, and liberty upon the government to make an inquiry. And
Government employee, they have misappropriated a huge amount of money. Within giving the beneficiaries, they have utilized, they have misappropriated entire amount. Now you are saying they are government employee. What about the government employee? Maybe it may be government employee. Let them face the consequences.
17, Lordship, after
Let them face
9
the
years back,
consequence.
Lordship.
Consequence. Let them face the consequence. They are government employee. They should not do all these things. Being a government employee, how they can misappropriate the government fund? Is it a rule? Can it be? Can it be that?
We did not miss.
There are materials against me, but still I'm doing because the period is not there. That's why I asked the IO to only to detailed period and make an inquiry report and furnish this. But it is not a case. They are government employee. Can they
Absolutely right, Lordship.
misappropriate fund and you have submitted? So what? They are government employee. Let them be face the consequence.
Departmental
Or otherwise, I'll
continue
state that
any point of time,
your bail petition can be rejected today itself, because there are materials. That effort I have just asked that whether the misappropriation period is proper or not. That's why only I asked the IO to make an inquiry. It's not because of because of your submission, because I have gone through the case record. There are some things, because misappropriation is directly against you, all the witnesses. But still I have shown that the period we want to see. That's why I asked the IO to make a detailed report. It's not a case of bail.
Misappropriate since 2016, 17 to.
That's why you have passed the furnish immediately you submitted that 16-17 period, but there are some 2021 period is also, but that's why I ask the IO to make a clarification in that regard. A government employee cannot misappropriate fund like this.
Absolutely right, Lord.
You cannot
we are ready to
instigate a person to be government employee. What's a government employee? They should not do all these things. Being a government employee, is their duty to do all these things.
Your Lordship, the Panchayat Act is very much clearly laid down. Section 29.
क्या दिलाने council for the petition? Vote अकेले लिखो 17, 16, 16, 17. And also heard Mr. KK Das dilaने be appearing on behalf of state. CD receipt, but it is submitted by Mr. Das that the that detailed inquiry report which was asked by this court by order dated 20/03/2026 is not available in the case. However, it is seen that the case is pending for disposal since 2025. Considering this aspect of the case, the IO is hereby directed to furnish the detailed report of inquiry as directed by order dated 20/03/2026 on or before the next date of district without any. In default, he may be served with a personal so CD be returned accordingly. List the matter but can be listed.
After vacation, we took the interim or
Yeah, interim was there.
interim. After vacation, Lordship on 16 July.
16 July.
No, Lordship on Lordship
Pending
22nd,
2025
22nd June, Lordship, if possible. Then 12, Lordship. 12.
12th of June.
12th
Yes.
June.
Don't make it
Lordship.
so like this 25.
Lordship.
12th of June. Very while issuing the notice, the order of 20/03/2026 be accompanied with the notice.
Look.
You take out a copy and then you.
Actually, I am not aware of the earlier order, Lordship.
Detailed order I have
Not,
passed.
not.
Lordship. My humble prayer, Lordship, kindly matter may fix on next week, Lordship. My senior is absent today due to illness.
Who, Mr. Sinha?
Yes, Lordship.
You ought to have mentioned in the morning, but
Oh, you could.
I'm waiting for
Yes,
that.
definitely. He is waiting.
very unfair.
Yeah, other argument was going on prior at 2 p.m. also you could have informed.
Lordship, I am unable to contact senior counsel, Lordship.
If you are unable to contact, but you are not in a position to suppose argue the matter, then
I'm not present, Lordship, in mention time, Lordship. I'm really sorry.
at mention time we are not present. When you see that one matter is going on since say 11:30 or something like that, most probably by from the 11:30 or 11:20 or something. So in that case, at 2 p.m. we could have informed us. Anyway, you are Mr.
Is Islam, Lordship.
Heard Mr. H. is the learned counsel for the petitioner. Heard Mr. L. Kapora, the learned counsel for the respondent. It is submitted by Mr. Islam that the NTS counsel, Mr. B. Sinha, is not available in the court due to some and accordingly paid for it. Where around this we listed on 12th of June. Was there any interim? No.
Interim is there. Lord.
Interim was
is
there.
Interim may be
12th of June,
continued.
interim be continued till next year. Okay, by continuing on we are listing it on 12th.
Hi, Lordship.
May I please, Your Lordship? Proceeding in these matters, service report is awaited to the respondent number 2, Lordship.
Respondent number 2.
2, yes, Lordship. Can you fix this matter after 4 weeks, Lordship?
What is the order is there in repost on Iman? Acha, acha. Your is it
Last occasion?
last occasion on 4/5.
Yes, Lordship. On
not
that day, I
taken.
have taken, Lordship.
Now you have taken.
Yes, Lordship. As per the office note, last date is 28. Most
Is
probably.
awaited.
Yes.
You are Mr.
PJ
Bora?
Dutta.
Huh?
PJ Dutta.
PJ Dutta, the learned counsel for the petition. From the office note dated 20/05/2026, it is seen that services steps have notice has already been issued to the respondent number 2 and the service is still awaited for. In view of this, let the service be awaited till next date of listing. Do you want any fixed date or after 2 weeks?
After 4 weeks.
After 4 weeks as an
Oblige.
Okay. Do you have any matters?